maybe it's only for your method. Oh. So when the dig oh,
For motion, item number 1 and 2.
Lordship.
Yes.
Here is a portion of the order dated 62 by the special fast track court Dimapur. Lordship, this prosecution case resulting in the conviction of the appellant is based on a FIR filed by the PW1. After the commission of the offence, it took around 15 days to file the FIR, and the FIR is filed on the basis of the state on the report by PW2, who happens to be a local research there. He saw the accused appellant taking the girl in his custody, and for 15 days he is silent, and one fine day he meets his parents that this has happened to your girl. Then they went to the Gauhati. He writes an FIR and files his case. And in the medical repair and other things, nothing is there. Nor there in during this 15 days, no abnormal behavior, nothing is found on this guard, Your Lordship. And there is total contradiction between the witnesses' statement. Nothing is there in in the medical report, Your Lordship. These are basically laborers who come from Assam to work in the brick field, and they are here for the bread and butter, Your Lordship. So,
Mr. Counsel, first we have to condone the delay has been condoned.
no, Your Lordship, this matter was listed before the principal bench, then it was sent here. We filed it before the principal bench, Your Lordship.
Who is appearing for the state? Yes, yes. Mr. Counsel, come here. Appellant Counsel, come here. Yes. Why there has been a delay?
Basically, Your Lordship, these are all ignorant, illiterate people. They don't know anything about this. They have approached us. It's like a social service being done to them. We have told that we have got a right of appeal. You can file a case there. We have made out a case. They are daily wage laborers, Your Lordship. So, availing their legal rights only way before Your Lordships. They're totally ignorant. He was arrested instantly and he's been in imprisonment since then only. He never filed a bail petition.
Mr. Counsel, we will condone the delay today, but we'll fix the matter for on Wednesday.
Lordship, I have to come on I'm coming traveling from Gauhati only.
Why do you have to come from Gauhati? There's always a video conferencing you can do. If you want, if you don't
Yes.
want, that's your lookout.
Yes, then definitely reflected in the order, Your Lordship. So busy.
Not necessary.
Oh,
We grant permission whenever we have. This is an application filed under Section 5 of the Limitation Act for condoning the delay of 239 days in preparing the accompanying appeal against the judgment and order dated 16/3/2023 passed by the fast track special court case fast track by the learned passed by the learned special judge Posco at Dimapur in connection with fast track special. Judgment and order dated 16/3/2023 passed by the learned special judge Posco at Dimapur in connection with fast track special case number 003/2022. We have perused the said application and we are of the opinion that taking into account that there is a right of filing an appeal, the delay in preparing the instant appeal on the grounds shown amounts to a sufficient cause within the meaning of Section 5 of the Limitation Act. Accordingly, the delay stands condoned. The registry and I stands disposed. The registry is directed to list the appeal, accompanying appeal along with the interlocutory application seeking for bail on when days on 28/2/2024. Take it on नाम तो लिखी थी. You appear for the state.
Not
They are only condoned the delay,
Not-
but let us stay. But one thing, this is a case on the POSCO. So considering the same, we may have to, have you made the informant a party here?
Yes, yes, Lordship.
To the informant has been made a party. No? We'll consider the bail on next date, on 28th.
Oblige, Your Lordship.
Mr. Lordship. Lordship, I beg to mention hearing item number 16 and 18. Lordship, on behalf of Mr. Young, I was informed that he's not keeping well for the past few days.
You are mentioning
On behalf of Younger Waters,
which items?
16 and 18. Hearing item 16 and 18.
Item number
16 and 18.
16 and 18.
Yes, Lordship.
Okay. Let it come up at the request of the learned CG86. Matters can be adjourned to be listed after 2 weeks.
Please, Lordship. My lord, I beg to mention item number 14 of the hearing list. My lord, if this can be taken up on Thursday, my lord.
Why?
My lord, I have some difficulties.
Don't worry, I have a long parted to take up. It may not reach. If it reaches, then I'll take it. Let us pick up the list. Don't worry. I have a long parted to take. I'll deliver the judgment. Thereafter, the cold weather may forbid me from sitting more. So under such circumstances, don't worry.
This can be fixed on Thursday, my lord.
No Thursday. Thursday, I have a lot of other matters. Your colleagues have already taken the time and fixed matters on Thursday.
May I please, Lordship? Lordship, I beg to mention hearing item 15. Lordship, this matter may be listed after with Lordship.
We'll see when the matter reaches.
For motion, item number 19 from the supplementary questions.
Oh, is this the matter connected with that matter?
Yes, Your Lordship. Item 13. The regular list is item 13 and 19.
So let us take both the matters together at that point of time. In connection with item number 13, na?
Yes, in the regular list.
For admission, item numbers 1, 2, 3.
That item number 1 and 3. 2 is the bail matter. Item number 1 and 3 basically challenges, my lord, the initiation of an investigation at that point of time, which now has culminated in filing of a charge sheet. And the basic issue is jurisdictional. Whether the then anti-corruption branch, Vigilance of Nagaland government, now the Lokayukta, under the Lokayukta Act, has got the jurisdiction to initiate, my lord, a criminal proceeding of any sort, not to speak of, my lord, penetrating a criminal trial against the private citizen. My lord, my basic, my lord, submission was, my lord, I've just in para 22, 23, and 28A, I've summarized the basic proposition. My lord, under the erstwhile Nagaland Vigilance Commission, the Vigilance Commission was propounded by an executive action. It's not a legislative action, my lord. Anyway, my lord, Vigilance Commission was, to my reading, my lord, empowered to investigate in respect of public servants of different kinds, and public servant will also include, my lord, officers of government companies, corporations, etc. They are to investigate, recommend to the government, my lord, whether penal action should be taken, whether disciplinary action should be taken. In some cases, they are also competent to conduct disciplinary proceeding as a, my lord, bureau, if the government so empowers them or gives them the responsibility. My lord, after the Lokayukta Act has come to force, by section 36, Lokayukta takes over all the pending investigations before the Vigilance Commission. Now, that, to my humble submission, my lord, will include only those investigations which are legally tenable and could have been pursued or taken over by the Vigilance Commission. Number two, Lokayukta Act is more, my lord, specific. It's an act of the legislature. It says you will not take any matter enumerated under Schedule 2 of the Act. Schedule 2, my lord, just, I'm sure, my lord, your lordships have seen. I'll just read Schedule 2 for my lord, lordships. The Act was there. My lord, Schedule 2 is the last page. second schedule. A, we skip. B, we skip. C, my lord. Action taken in matters which arise out of terms of a contract governing purely commercial relations of the administration with customers of supplier, except those or complaint alleges harassment, gross delay in meeting contractual obligation. My lord, the allegation against me is I have installed a my lord machine. I think what do they call it? MRI machine. I've installed an MRI machine in hospital here. After I become successful in a public bidding system, my bid was accepted, and at my quoted bid, I was given the order. I supplied it, installed it. It is running till date. There is no allegation to that. Allegation is you have made undue profit. We have seen that the machine costs about 9 crores and odd, while you have charged 14 crores and odd from the government. That is the allegation. My lord, 14 crores of odd. I'm not defending any act. My lord, this is not the forum. But my lord, it's fate accomplished that I was given the order at my quoted rate by the government by way of an open tender system, which is not yet put to question. Number two, there is in the charge sheet one single line I must tell to your lordship that they have got evidence to say that all the tenderers were from the same house. It belonged to me. My lord, these are different entities. Good enough. If you have it, you must have in the charge sheet say, how do you say that these are all by the same person? Everything said and done, these are admittedly private citizens on whom the prosecutor of the day, the Vigilance Commission or Lokayukta, who are the respondents before your lordship, doesn't have an iota of jurisdiction. My lord, I'm not troubling your lordship with any case law and other things.
Now, what are you challenging out here? So many matters, why?
My lord, this matter was challenged way back in 1st 2017.
18.
My lord, 17, your lordship will see, this is the funniest part. My lord, 17, we challenged the initiation when some notices were given to us. We came up before this honorable court, my lord, page 22 of item number 1, amended writ petition. Page 22 of item number 1, my lord, 74K. Lordship got it, my lord.
Page 22.
22, it should be annexure 1, my lord.
Yes.
My lord, this is the first round of litigation. My lord, by 17-1, notice was issued. Kindly come to the next page, my lord. When asked with the jurisdictional part, they told my lord, we are withdrawing all the notices against them. So, my lord, we did not press it. The same case. Then comes this present case, my lord. They again start notices telling that you are required in connection with this. And the crescendo comes, my lord, when I pray for a copy of the FIR. And they say, oh, we are sorry, the FIR copy cannot be given to you. Lordship may kindly come to page 30 for a moment. 30. Annexure 8. I am to refer to your letter dated 6/3 so and so, and to convey that this police station will not be in a position to furnish a copy of the FIR and other materials to you at this stage of the investigation, as the case is of sensitive in nature. My lord, I somehow get a certified copy, and this is the copy, my lord, page 30. Kind, my lord.
Page 32.
Page 30.
32.
30, my lord. 32, I'm sorry. 32. I'm sorry, 32. My lord, kindly see name of the complainant, Deputy SP of the Anti-Corruption Bureau, name and address of the accused person. These are the petitioners before your lordship. They named the, my lord, this form, and my lord, others include us, because we have been, our accounts and other things were tried to be seized. Kindly see, my lord.
No, name and address of the accused person is,
Kotuni Enterprise,
that is you,
yes. Represented by,
so and so and others involved in the case.
yes.
Who are the others?
My lord, me and my wife, we are shareholders of this enterprise. This person, Mr. Venu, is the manager.
Is there any allegation against any public official?
Yes, we can fish out, my lord. We can fish out. Based on the preliminary investigation conducted by so and so, case is now converted to criminal case. On the basis of a preliminary investigation, primary evidence that the total sum of so and so released under so and so for setting up MRI unit, so and so was paid to so and so, installment one in so and so in running in so and so. From the preliminary investigation, it is ascertained that budgetary quote of so and so for the so and so was 5 crores, no 5 lakhs, 5 crores. Whereas details of the bill submitted by so and so MRI machine, including transportation, so and so, including so and so, civil works was 16 something. During the course of preliminary investigation, the statement of so and so, it appears that the entire cost of the machine up to installation was, my lord, 4 crores 68 lakhs.
There is no allegation against you, against any public official.
No, apparently not. Apparently not. My lord, if we try to fish out, probably, my lord, that government had given, then we fish out who are the government official who had given. That way. Otherwise, no. This is a investigation and prosecution against me, who are admittedly private citizens, my lord. My lord, I will not trouble your lordship with the virus of the sections alleged against me. My lord, undue profit, undue benefit, profit, my lord, in my humble understanding, my lord, is not a penal offense. Even admitted, let us admit for the time being, my lord, that is an undue benefit.
Now, what have you challenged therefore in the first?
My lord, I have challenged the initiation of the particular case against me, which is numbered as, my lord, I've given the FIR number, which is the RC 10 of 2017, and everything flows out of that. Lordship will get, my lord, at page 32, FIR number RC 10 of 2017. This is the number under which the entire, my lord, we call it case, we call it prosecution, we call it investigation, everything is proceeded with. RC 10 of 2010, my lord, I prayed that the entire case should be set aside, my lord, by this honorable court. My lord, I tried to quote the relevant portions of Vigilance Commission in page, my lord, para 21, para 22.
Where is the powers of the Vigilance Commission given?
My lord, in the Vigilance Commission, my lord, para 22 is a brief summary. If your lordship has this, my lord, it was there in the judicial file. State Vigilance Commission, Nagaland. I have given a compilation, my lord. It's a government. It should be there somewhere in the file, my lord. In two files there.
Yes.
My lord, yes.
What does it say? What is the powers?
My lord, kindly see clause 2, the first page itself. The State Vigilance Commission will have jurisdiction and powers in respect of all matters enumerated below. Namely, to undertake any inquiry into any transaction to which public servant is suspected or alleged to have acted. Then cause an inquiry or investigation to be made in the complaint that a public servant has exercised. To inquire into complaint, corruption, misconduct, lack of integrity, other kind of malpractices, misdemeanor on the part of public servant, including members of All India Services. To make recommendation as may be appropriate after inquiry or investigation to the department of the government.
So here public servant is not required. Number D.
To make a yes, they can make a recommendation. Let us come to, my lord, they can make inquiry or investigation and give it to the department. My lord, they have taken up the role of prosecutor of the state. They are the prosecutor who have filed the charge sheet against me, naming me. To initiate at such intervals conditions, suitable review of the procedure of practices in administration, or she may keep, to collect such statistics to submit an annual report. My lord, kindly see 3 also, a conjoint reading. The State Vigilance Commission shall have jurisdiction over public corporations, statutory bodies and undertakings of the state which have passed resolution agreeing to be subject to the jurisdiction of the commission. My lord, subject to correction, my lord. They have got right to examine someone, any person. That's not limited to public servant. But when
Now,
it comes,
in their course of investigation or the charge sheet which they have submitted, where I think you have challenged it. Did they come up with any finding to the effect where the public servant is involved?
to my humble understanding, no. It is aimed against me. And my lord, kindly see the FIR. They probably cannot travel beyond. What is the allegation? They are trying to justify the allegation in the charge sheet. Undue benefit by me.
Let
And
us
the-
see, this is the second repetition, huh?
My lord,
Where is the charge sheet?
my lord, the charge sheet is filed very recently. It is separately submitted, my lord.
IA 149 of 2020 filed by the petitioner. IA.
Thank you. Thank you.
Is an I.
Yes, thank you, my lord. This was disposed of by an order, but still, my lord. In that disposed of matter, page 18 is the charge sheet. My lord, it was disposed of by your lordships by an order dated 14th of December. Only for records, my lord, page 18, if your lordship kindly bear with us.
Relevant portion 33, page 33.
Page 32.
My lord. Yes. Some acts and present. Now, from 4, our names start. 1, 2, 3 are the other. 4 is at page 36, my lord. Internal page 25.
So they have now investigation. With this investigation, now they have said that one Mr. So-and-so, Health and Family Welfare Department and former,
Yes.
he is involved.
My lord, the first question is, my lord, I am not appearing for others, but my lord, when it comes to a holistic examination, where is their power to file a charge sheet?
Huh?
Where is their power to file even a charge sheet? To be the prosecutor for the state?
Why?
My lord, your lordship has seen the State Vigilance Commission.
Huh.
They can only recommend.
Huh.
They cannot be the prosecutor. My lord, for the purpose of summons and other things, they are declared to be a police station under section 2S. Nothing more than that. My lord, just by.
But what do you say about 2B? To cause an inquiry or investigation to be made on any complaint that a public servant has
Yes,
exercised or refrained
Yes.
from exercising
Yes.
his powers.
Yes. And my lord, C also, and then D, my lord.
So, under sir, maybe the FIR cannot be said to be an encyclopedia.
No, I will not say so. But the FIR cannot culminate in a charge sheet. That prosecution's, my lord, power, in my humble submission, the Vigilance Commission never had, and the Lokayukta also does not have. Even against, my lord, I am the distinction of public servant and private citizen apart. They cannot prosecute anyone. And when it comes to me, they cannot even investigate a case against me. And my lord, the act makes it more clear. Now the prosecutor is Lokayukta, my lord, the organ under the Lokayukta. Second schedule makes it clear you cannot do this. What can they do is also there. Section 8 and 9. Would your lordship kindly come for a moment to the act, my lord? Madam, Lordship has got. My lord, Nagaland Lokayukta Act 2017. If your lordship may kindly peruse, section, my lord, 8. Up till 7 is, my lord, conditions of service and other things. Section 8, matters which may be investigated by Lokayukta or Upalokayukta. Subject to provision of this act, Lokayukta may investigate any action in which is taken by or with the general or specific approval of Chief Minister, member of so and so, Vice Chancellor, so and so, so and so, so and so. Lokayukta, any other public servant. Lokayukta, Lokayukta, if it thinks fit, investigate an action taken by or with the general specific so and so of a public functionary if it is referred to by him by the state government. And then Lokayukta may, for reasons to be recorded in writing, investigate any action which may be investigated by Lokayukta. My lord, section 9 are the differing clauses. Except as herein are the provider Upayukta shall not conduct any investigation under this act. In the cases of a complaint involving a grievance in respect of any action, A, if such action relates to any matter specified in second schedule, my lord will come to second schedule little later, the lordship is to peruse, or if the complainant has or had any remedy by way of proceeding before any other forum, provided nothing in clause B shall prevent the Lokayukta from conducting an investigation, the Lokayukta case may be is satisfied that such person could not or cannot for sufficient cause have recourse to such remedy. My lord, here a police officer is the complainant. Could we, and that satisfaction is nowhere there. It's not even recorded. The Lokayukta shall not investigate any which formal public inquiry has been ordered, B, any action in respect of matter in which has been referred to inquiry under the commission of inquiry. Lokayukta shall not investigate any complaint. Expiry of 12 months, any complaint allegation after the expiry of 5 years.
Now, does this act say anything about
Previous.
those proceedings which were being continued by the
My lord,
Vigilance Commission?
my lord, section 36. The saving clause, my lord.
Yes.
Sorry, I'm sorry. Yes. My lord, the repeal section. See, resolution the
So 36(3).
3.
So any proceedings which were started by under the Vigilance Commission would deemed to be continued here.
Yes. No, my lord. That's how I'm before your lordship. The jurisdiction of the initial investigation is under challenge before your lordship. My lord, an act of the legislature, when it says, my lord, all inquiries and investigations, it will be, in my humble submission, all inquiries and investigation which legally could have been taken up by the Vigilance Commission. Not anything and everything, my lord, which is even pending challenge before a judicial authority, a constitutional court.
So therefore, your submission would be as regards when the Vigilance Commission did not have the initial jurisdiction, the question of further proceeding, but even if
My lord,
Lokayukta had the jurisdiction.
My lord could not have been coined in better words. Yes.
But what do you say about the FIR? Yes, upon investigation, which was found out there was some anomalies being committed by those officials, which not floating a tender in a proper manner. And that is the reason why this has happened. And accordingly, there has been a loss which is occasioned to the state.
First of all, whether it's a loss at all.
No,
because
the
the
question
state,
of whether it's a loss at all is not the subject matter for this court to decide.
absolutely.
So this is for the trial court or whatever.
My
we
lord,
have those
I'm so
evidence.
blessed. I'm not inviting your lordship to that arena.
So the question out here is, if an FIR may not have stated anything, is it your submission that the FIR does not say anything that the initial jurisdiction which is being exercised by the Vigilance Commission was bad? Maybe whatever they may have found later on.
My lord, I'm not telling that a wrong cannot be remedied. But in a society governed under law, the remedy lies in the particular forum which has got the jurisdiction to do the remedy. My lord, I may go to the extreme example of telling that I know a murder has been committed. I cannot give it to a district judge to try it. Maybe the same person sits in his other, my lord, chair as a sessions judge, but the district judge will not hold a 302, my lord, trial. It is almost like, my lord, here this authority has not been settled with any power to take up the role of a prosecutor. What it can do, the initial authority, investigate. During the course of investigation, they can summon me, which I have never refused, my lord. I've cooperated with them. It's not their case that I have not cooperated. They can investigate, they can recommend to the government the actions. Now, government has got wings, my lord. Either disciplinary proceeding or normal penal proceedings. Whatever. And those proceedings will continue at the hands and at the forums which are entitled and appointed by law, my lord, to conduct and do that. Not this.
Mr. Day, what do you say about this proposition? There are various judgments of the Supreme Court who say that you cannot initiate a proceedings under 156(3) against a public servant without taking recourse to the sanction. Now, that was the law which was going on. Then that law has been now referred to a constitution bench by another judgment by, I think, Justice Salvesh was sitting out there in the division. It was also both a earlier judgment was by Justice Sikri and now by Justice Salvesh. I think the name of the party was. Now, there, an interesting, although the matter has been referred to a larger bench, an interesting observation was made that yes, I cannot touch on this, that the law as regards without a sanction made under having a sanction under 197, proceedings under 156(3) cannot be done. But it was also said that if under 156(3) it was done against somebody else, and in the way there is another person who comes who is a public servant, then it is during the course of the investigation, if it happens, then the sanction is not required.
My lord, kindly see. Here is an authority not bereft of the jurisdiction. There is a sine qua non for exercise of the jurisdiction. Here is an authority which is bereft of jurisdiction. It's not a question of how you exercise it. It's a total absence of jurisdiction. It's not a question of how they exercise it. There is a question of an authority having a jurisdiction and a procedure established by law, my lord, by which the jurisdiction will be exercised. My lord, here, even at the stake of repetition, the authorities don't have the jurisdiction at all to take up the role of a prosecutor against a private person. Even against public servant also, they cannot be the prosecutor. They cannot take up the role of normal police, my lord. For that, they have to go to government. Government, if it thinks fit, will go to police, will, my lord, invoke its jurisdiction. It is not a case where they had the jurisdiction, but for some, my lord, sanction or other things, they are wrongly exercising jurisdiction. No. It's total absence of jurisdiction, my lord. We are conferring authority on an authority which doesn't have the authority to exercise the authority.
But what do you say if in the FIR there was an allegation that with the help of public officials we could get the tender?
Good.
Then in that case?
In that case, they have got recommendatory power against the public servants.
No, why not under 2B?
Yes, against me also.
No, again, under 2B, to cause an inquiry or investigation to be made against a complaint that the public has exercised or refrained from exercising his powers for improper corruption.
Yes.
Now, if there was an allegation against those persons who were the director of health at that point of time, that look here, that the director of health was responsible in giving him the tender without floating in as such. So under such circumstances, kindly carry out. The FIR had contained that.
My lord, I'm
then
not
in
their
that
advisor.
case, the jurisdiction would have been there.
My lord, I'm not their advisor.
No,
but
I'm not saying. Why I'm saying it.
Yes.
We also have to look into that. A FIR is not an encyclopedia. So it may not contain many aspects. But your therefore submission is, on the face of the FIR, there is no jurisdiction upon them because it was straight. only mentioned against you.
Yes. My
That's
lord,
your case.
even if the FIR would have mentioned all their names, then also they cannot, under any law for the time being in force, take up the role of the prosecutor. Appeal investigation, I am not questioning their power. You cannot be my prosecutor. My lord, law has defined the role of a prosecutor, which is by a particular organ of the state. Everybody cannot prosecute in the name of the state. Investigation, yes, my lord. And my lord, again, I'm telling, I'm not their advisor, none of us are. My lord, given my case, I would have told, recommend to the government, hang them. Even a private citizen, my lord. Even a private citizen, how can he go away? Suppose abatement, how can he go away?
So you mean to say that the charge sheet may be the charge sheet may be okay, but it is bad insofar as against you.
My lord, charge sheet and the entire prosecution is bad so far as I am concerned, because I cannot stand for others.
No, because for others, if I, as per your submission, that whatever may be, they can at least, they can only make a recommendation. Otherwise, they cannot do anything against a private individual.
My lord, in fact, against a private individual also, they cannot even probably investigate.
No, that is what. They cannot investigate or anything. But the moment the private individual comes, it becomes recommendatory in nature.
Recommendatory in nature. Along with the public servant, my lord.
And on the basis of that recommendation, the police can, the state can very well
Yes,
carry
yes.
out any,
Yes.
do whatever may
Yes,
be.
yes.
So therefore, the charge sheet may be good insofar as the others are concerned, but not against you.
Absolutely. Because, my lord, we are probably not even settled to address this issue because they are not there before us.
No.
Your lordship.
So therefore,
I understand.
if
It's
they
a
could
question of
not
law.
have investigated you, then in that case, they could not have submitted a charge sheet against you.
My lord, they could not have submitted a charge sheet not only against me, they could not have submitted a charge sheet even against the public servants.
Why?
My lord, there is no role of a prosecutor given to either Lokayukta or this. My lord, kindly see, it is inquiry on investigation. It is limited to that. And when it comes further, recommendation.
Now,
My lord,
they
close to.
become police under you said some provision, 2S or something.
2S, my lord, is a police station. Because if it is not a police station, they cannot even summon me. They cannot exercise jurisdiction under section 41. Investigation.
What is
Yes.
the power? Let us see.
My lord, clause 2 is the crux of the jurisdiction.
Clause 2.
Clause 2 of that Vigilance Commission, my lord.
This is a resolution. You are reading the
My
resolution.
lord, yes,
It is done by a resolution.
it is done by a resolution. My lord, I'm not taking your lordship to 161. If I can take your lordship to 161 also. I'm not inviting this honorable courts, my lord. And my lord, the most interestingly, they say they will bring up a legislation to effectuate it, which has not been done till date. But I am not on that. My lord, after the Vigilance Commission, there is a notification of declaring it to a police station under section 2S, my lord. But that doesn't add to their jurisdiction, my lord. Jurisdiction will come from clause 2. Nothing more, nothing less. Because, my lord, CRPC says how the police files, my lord, in such a case, how the police files a charge sheet. It is limited to police. And only because they are a Thana, they are not police people. They are not police under CRPC. Thana for the person of section 41, 91, okay.
And more particularly when section 2O. of the CRPC defines the officer in charge of a police station.
Officer in charge is yet to be, my lord, to my
No, no.
knowledge, they have not brought out.
No,
anything.
no, I am saying. Section 2O of the CRPC defines officer in charge of the police station.
My lord,
And that particular authority has been given the power under 173(2). So it cannot be the police station who can. It has to be the officer in charge.
yes, my lord. Someone probably has to be declared to be an officer in charge for the purpose of that, cloaking him with the power. Only because he is the officer in charge of Vigilance Commission will not make him an officer in charge under 2O. I am obliged to your lordship. my lord. But if you can kindly see, my lord, police report means a report forwarded by a police officer to a magistrate. Only because incidentally they were police officers drawn to Vigilance Commission. Vigilance Commission is given the sanctity of a thana for many other purposes. It doesn't become a police report.
And the power which has been given out here does not include the power to submit
Charge sheet.
a charge sheet.
My lord, I will say a broader word probably to prosecute.
They may carry out the investigation in view of 2A.
My lord, 2A,
2, but
2B.
in view of 3,
Yes,
they cannot submit the charge sheet.
I'm blessed, my lord. They can probably go to D and make a recommendation. Recommendation as may be appropriate after inquiry investigation to the Department of the Government. Then law take its own course, my lord. My lord, it is precisely
Now,
because
who
of,
submitted the charge sheet?
my lord, this,
The lokaयुक्त,
no, SP of the Vigilance Commission.
Vigilance Commission.
Vigilance
did.
Commission.
And what is the role of a lokaयुक्त here then?
My lord, Lokayukta
When
takes
was
up-
the charge sheet submitted?
My lord, he was the SP and IO of the case. Now he uses the seal of Nagaland Lokayukta. That's all.
So who had submitted the charge sheet?
My lord, he is some SP and IO. I will read it to Superintendent of Police and Investigating Officer of the case. My lord, the charge sheet, the last page. Now she has seen that 149. It should be at page. My lord, page 40 will be the last page of the charge sheet. Last charges, IA page 40, my lord. 40.
Special judge. No. Who is the person who was on SP and IO?
Of the case.
The SP.
Open to me. Every page, my lord, contains the thing, seal of special judge,
No, you got a certified copy from the special judge.
special judge. Yes,
That is why he.
yes. My lord, why I'm saying this, the charge sheet as such does not even have the seal of the government. It doesn't have the seal of the government, the authority under whose jurisdiction it is filed.
How do you say that this charge sheet is in connection with that investigation?
My lord, yes.
Normally in this.
My lord, kindly come to page 18, the first page of the charge sheet.
Yeah.
My lord, the front, brief facts of the case and charges in RC 10 of 2017.
Understood. RC10 is what?
RC 10 is the proceeding, my lord, under challenge before your lordships. I prayed for quashing of these only. This is under this nomenclature that they're doing everything. Notices are being issued. I am being suborned. My lord, my anticipatory bail application was being opposed. The FIR is also, my lord, quoting this particular number, RC 10 of 2017. Everything is under this number.
Yes, Mr. Jamil, who has given the charge sheet? Mr. Jamil? Oh,
Now look.
he's the SP
Yes.
of the Lokayukta.
Yes.
Okay, Mr. Day, I have understood your point. Let me hear him and I'll ask.
My lord, I just pass over the citations, my lord. If there is something to do, done under law, it must be done exactly in accordance with that law, not at all.
Yes, Mr.
Matters, Lordship. Lordship, I might bring for response number 5.
Lokayukta.
Then, Lordship, I have not filed any affidavit, but I'll be relying on the documents because placed by the petitioner. Now, before I come to the merit, Your Lordship, on jurisdiction, I will be allowed to make 2 short preliminary submission. Your Lordship. It will just take 5-6 minutes. Your Lordship, my first preliminary submission will be on the conduct of the petitioner. The petitioner did not approach this court with clean hand. There is misrepresentation and suppression of material facts, Your Lordship. May I take Your Lordship to para 2 of the writ petition? What writ petition 74? Lordship has got it.
Of the amended?
Amended.
Yes.
That the petitioner being husband and wife are businessmen by profession. The name of their firm is MS Virginia Enterprise, with its principal place of business and office at Burma Camp Road, Walford, Dimapur, Nagaland. Para 12, Your Worship. See. Para 12. That the petitioner beg to state that their firm, namely MS Virginia Enterprise, is a registered contractor and supplier under the Department of and is engaged in the business of government supply of medical equipment devices in branch. Now, for a moment, Your Worship, what is the finding? May I take Your Worship to IA 149, the charge sheet? IA 149. I will be referring to that IA, Your Worship, from time to time. Page 18, Your Worship. This is the charge sheet. And relevant page, Your Worship, I will take Your Worship, page 31. Page 31, Your Lordship has got it.
Yeah.
Serial number 7. Sri Kodusulu Benu is his statement, and he is the petitioner in the other writ petition 60, Your Lordship, WPC 60. May I read out? What does he say about the firm, Virginia Enterprise? Sri Kodusulu admitted that he is not the proprietor, owner of MS Virginia Enterprise. Virginia Enterprise was owned by Kodini, but Kodini expired, but he does not know who Kodini is. In this case, Your Lordship, the bid was submitted in the name of Kodusulu Benu, as proprietor. The bid for installation, supply and installation of the MRI machine, Your Lordship.
Who submitted?
Kodusulu Benu, as proprietor. Now, next para, Your Lordship.
And how is Amit Sarkar involved?
That is the thing. That is why I'm coming. There's misrepresentation, suppression of facts, Your Worship. Now, next para, may I read out? Next paragraph. On being asked if he is not a proprietor, how come he has signed in all official correspondence as the proprietor of MS Cordini Enterprise? He admitted that it was through DI Solo. He is also important, Your Worship, DI Solo, that he joined MS Cordini Enterprise. DI Solo and he knew each other, and one fine day, when DI Solo saw him jobless, he told him that he will give him a job in Cordini Enterprise. The deal was that Kodosolo will be employed as the proprietor of the company, MS Cordini Enterprise. And like the owner of the enterprise, he will have to sign in all the papers. Moreover, all contract works will be done in his name and he will be paid for the work. May I take your lordship to page 33 also?
The charge sheet has not been put to challenge. Huh?
No, charge sheet is not challenged.
My lord,
I'll
charge
become-
sheet as a separate document is not on challenge.
I'll
What
become-
is under challenge, my lord? At the relevant point of time, RC, that, my lord, the number under which even the charge sheet is filed today is under challenge. My lord, 10 of 2007. Yeah, everything flows under that.
May I take your lordship to para 33, page 33? Fourth para from the bottom, in the middle, your lordship. Investigation also revealed, your lordship has got it? My lord has got it? Investigation also revealed that Cordini Enterprise was registered under Government Registered Class 1 Contractors Union on 30th September 2003. However, the firm bearing government registration number such and such, the proprietor is Nepika M. Khoza. Petitioner is claiming that he is the proprietor, he and his wife, in this petition, para 2 and 2 of your worship. And not Kedisulo Venu, who is the petitioner in writ petition 60, where the photograph submitted in the union also belongs to Nepika and Khoza Sensi. And Nepika was also examined, your worship. Nepika also admitted that the photograph belongs to him, your worship. Now, what I'm trying to bring to your worship notice is the statement made by the petitioner in para 2 and 12 to read petition, your worship, is talking false. There is misrepresentation, the separation of material facts as regards the status and standing of the petitioners, your worship. And when it comes to separation of material facts, more misrepresentation, your lordship, the law laid down by the Honorable Apex Court is clear, your lordship. And in that condition, I may be allowed to refer to one judgment, if my lord allows me.
Who is Nelly Khoza?
Namely, the wife of,
And who is the owner? As per this charge sheet is Nifiko Khoza.
yes,
And how is Nifiko Khoza connected with Nelly Khoza?
your lordship, this is what we call totally a bidame transaction. And who has submitted the tender documents? My lord, may kindly turn to page 20.
And who is the person who filed the second writ petition?
The first petition 60 was
No,
filed by
that I've seen.
the
Who
second,
files
the petitioner, your lordship,
The
yeah.
second is filed by,
by the petitioner and his wife.
no, second is filed by Kodosolo Venu. For those who know Venu, he claims himself to be the manager.
But he has been appointed as a proprietor, and he has he signed in all the documents. He submitted the bid for MS for the enterprise, and which the petitioner is claiming that he is the proprietor, joint proprietor, he and his wife. But the documents does not say so.
Is SPN IO
No,
is appointed under this commission, this Nagaland Act, that the Lokaयुक्त Act, that the Nagaland Lokaयुक्त will have a what do you call SP?
no, your lordship. May I take, for a time being, may I take your lordship to the compilation, which was submitted by the petitioner, the compilation. Vigilance Commission, that compilation, your lordship. The Vigilance Commission. The first resolution has been referred to. Second also has been referred to. May I take your lordship to page 10. This is a notification dated 9 December 1976. Your lordship has got it? Page 10. Whereas the state government of Nagaland declared the office of Director of Vigilance and Anti-Corruption Nagaland to be the police station under section 2 as of the Code of Criminal Procedure such and such. Now therefore the government of Nagaland in excess of the power conferred by section 2 as of the Code of
Page 10.
page 10 of the compilation. The bottom.
Whenever a complaint is received by the disciplinary,
Mm,
it's of the office memorandum of 12th of July
no,
1976.
9 December 1976, page 10 of the compilation,
Ah, yes,
page
yes.
10, bottom.
Well done.
May I read out?
Ah.
Whereas the state government of Nagaland declared the office of Director.
So he has been given the officer in charge.
Now, may I take your lordship to just relevant page 31. Page pagination is at the bottom. Lordship has got it. Page 31. This is the notification dated 21st August 1999. Whereas the state government of Nagaland declared the office of the Director of Vigilance and
No,
Anti-Corruption.
no. Page 31 is different.
Page 31.
Page 31 is some Department of Works, Housing and Public Health Vigilance. 19? Ah, 1979,
No,
16th.
21st August. Your lordship, I'm just furnishing the extra copy. 21st August 1999. Whereas the state government of Nagaland declared the office of Director of Vigilance and Anti-Corruption Nagaland to be a police station under section 2S of the CRPC by government under such and such. Whereas the state notification does not state the provision of the office under which the police station shall have jurisdiction. Now therefore, the state notification number such and such is here amended as follows. The following shall be added. Now therefore, the government of Nagaland in excess of the power in spirit conferred by section 2O of the CRPC declared the Director of Vigilance and Anti-Corruption to be the officer in charge of the Vigilance Police Station for the whole state of Nagaland with headquarters at Kohima. Further, the Director and the Office of the Director of Vigilance and Anti-Corruption shall be deemed to be police officer of the Vigilance Police Station and have jurisdiction and power to investigate into offences punishable under the following section of law as scheduled below. All offences under the PC Act.
So here, apart from that, other provisions is also being given.
Yes.
Following sections.
Section
all
406
offences,
to 409
406
IPC.
to 409.
Yes. 417 to 420 IPC. Yes, we have
Possible
investigated. We have
Very-
investigated.
very,
How to
very,
investigate?
very wisely, the parent notification is that resolution. This is only in addition to this, the last line, my lord, says very aptly, shall be deemed to be police officers of the vigilance position and have jurisdiction and powers to investigate, not to prosecute. They cannot file charge. My lord, because the parent resolution,
No, what do you have? Where is the question of prosecuting? Means investigate, I think in a criminal thing, there are three things. One is the investigation, inquiry and trial.
yes,
Trial will be done by somebody else, we are not on that. But investigation is to be done within the meaning of section, the provision. for
absolutely,
proceedings.
absolutely.
Yes,
My
which
lord.
will include
And
the-
kindly, my
The
lord,
investigation will only culminate with the submission of the charge sheet.
no, my lord, here the investigation will culminate to D, to make recommendation and nothing more. To inquire into complaints of corruption, to cause an inquiry investigation to be made by a complainant that the public servant is anyway. To inquire into, I am anyway out. I am anyway out, maybe as an avatar, if I come in, to make recommendation as may be appropriate after inquiry or investigation to the department of the government. It says it's not a general power of investigation inquiry. Why the investigation inquiry? At the end of the investigation inquiry, what you'll do, you'll recommend to the government as may be appropriate under the
What do you say about the investigation to be carried out? And more
Investigation.
particularly in view of this
My lord,
notification of line.
my lord, your lordship.
It
will
is
see-
a police station. It has an officer in charge. An investigation culminates
the
with
role of a prosecutor, my lord, because the role has been circumscribed. Role has been circumscribed.
No, but this notification is not put to challenge.
My lord,
Of
we don't know.
21st
See,
of August.
these are coming up in course of my lord arguments, not.
No, this is a note, when you are before this court, when the matter has been, I have taken up this matter earlier, that is why I have taken up this.
Yes, my
matter
lord,
today.
it was
Now,
never
the
brought to our
question
knowledge.
therefore is, you must, whenever you are before this court, now the counsel
lord,
for the petitioners obviously
to-
will have a better avenues to know what are the
My lord, a
notifications.
private citizen doesn't have, my lord, these are not matters which are public by, public domain. They don't come up with an affidavit. And my lord, today it comes out of the pocket. My lord, not even in earlier occasion, these were brought to our lordship. But my lord, having said that, I will humbly reiterate, my lord, my submission under their parent, my lord, power and jurisdiction is clause 2, which is not amended. And my lord, probably they cannot even amend it.
But Mr. Day, we are not concerned whether they have amended, they could have done more than that. It is not the subject matter. before
My
this
lord,
court.
kindly see.
It is very limited.
My lord, kindly see.
We are to see as to whether you have the
Yes,
jurisdiction.
my
You
lord.
had the initial
My
jurisdiction.
lord, yes, my lord.
But what do you say about you? How are you involved?
My lord,
How are you, how did you file the writ petition saying it to be your proprietor? And you are appearing in out here in item number 3, where he the manager.
my lord. Your lordship probably will not tell me to disclose my defense, but what he is reading.
No. I'm not going to disclose your defense, but when you have already stated you are the owner.
I am the owner.
Show me that.
My lord, kindly see one thing. I am the proprietor, my lord, for the purpose of this, my lord, this uh, contract or transactions, maybe for general or specific. My lord, I may use the proprietor seal. My lord, that does not make out a case of 409 by the government. That may have made out a case of 409 and 420 intra-party. Suppose.
No, I'm not on that 409. On the question of suppression.
No, there is no suppression. What is the suppression? If there is suppression, let them come up by an affidavit that in 161 statement can be rebuttal to my lord, statements
you-
on oath.
No, you are saying that you are the owner.
My lord, let's see what I see. My lord,
Paragraph number 2 of the writ petition.
my lord, your losses are with para
2 of the writ
74.
petition. para two.
I'm sorry, yes,
Paragraph number two
Para
of the
two,
writ
writ
yes,
petition.
yes. Who are these persons? Amit Sarkar and his wife. They are the owners. My lord,
Where is it? How do you say that you are the owner?
my lord, nobody has, none of my constituent has come to tell your lordship that I am not the owner. Government cannot come and say, my lord, who somebody else is posing it. My lord, I might have, my lord, for all intents and purposes, delegated my right to someone else for a particular transaction. My lord, kindly see what does the other petition.
There you have
The-
said that person is the manager.
Yes, yes. My lord,
Petitioner number two is the manager,
yes,
paragraph number
yes,
one.
yes, he is the manager and representing as the proprietor's man, my lord. It is not a misrepresentation, if any, must come from me or other constituents. It is not for the state to say, my lord, who will represent
Mr.
whom.
Day, when you are before this court, you are to come before this court in clean hands.
My lord, yes.
Yes.
And who says, my lord, Amit Sarkar has not said that he is not the proprietor. Amit Sarkar has come up before your lordship. By an oath, he says he is the proprietor. He and his wife are the proprietor. They quote someone else's statement to show that someone else is the proprietor.
Who?
They,
No,
the
no,
statement to your
no,
lordship.
your statement only, which you have enclosed out there.
Kototsolo Venu.
No, kindly see the IA. See your statement which you have been taken out there in that IA. And that's in the charge sheet.
Charge sheet.
What is your statement?
Yes, ma'am.
You say that this particular belong to the uncle of your wife, and he allowed your wife to use it, and therefore you have a power of attorney. This is what is your statement out there.
True, my lord. This is a transaction pre 2017, and these are papers post 2020.
So
A fund can, my lord. I am not disputing anything because I don't have anything to dispute. But my lord, taking the face value of all these statements before the police, fact remains it is 161. This may be, my lord, in the court of law told to be not my statements. Even then, my lord, I'm not disputing anything. My lord, the firm can undergo a change in last 5 years. Today it is, of course.
no, you have come before this court.
In 2018, my lord.
Whatever. You admit that you had submitted a tender. Do you admit that?
Yes, Cotonee Enterprise submitted a tender, got it.
And in the tender, what did you submit? Who is the owner? There you have to come. In the tender, you submitted the petitioner number two in the second writ petition is the owner.
Everywhere, probably, let me see. Tender papers are not
Isn't
there.
that, Mr. Jameen? In the
Let me
tender
see.
paper, he has submitted that the petitioner number two in the second writ petition is the owner, proprietor.
No, my lord, that part.
I'm coming in 5 minutes. You have a look.
Got it. I'm deeply obliged to your lordships. my lord.
Yes, yes.
My lord, I am always weak on facts. I'm always weak on facts, my lord. My friend is, my lord, kindly come to page 31. Your lordships were seeing what was read was the statement of Kodotsolo Venu at page 31 of the miscase, my lord. My lord, page 31 has been read over to your lordships. Lordship remembers that.
No, I have not only read page 31, I have also read page 36 and 37.
Yes, my lord, I'm coming to both.
Yes, wherein he says that that particular enterprise belonged to the uncle of your wife, and he allowed, because he was weak, he allowed your wife to run, and you have a power of attorney.
Yes.
That is what you say.
But my lord, he doesn't say that he is not the proprietor. That is not the statement. Police only record, let us assume those, police only record, my lord, what is convenient to them under 161.
No, I'm not on that. I'm only on the fact that somebody submitted the tender as the proprietor.
Kodotsolo Venu is, and my, I'm coming to that. I'm coming. Kodotsolo Venu says that he's not the proprietor. Kindly turn to the thing. Page 32, I'm just reading, my lord. So, as per the deal, all the papers related to Kodoni Enterprise, including checks, were signed by him. He appointed, wrong English, he is appointed as the manager. My lord, now, this manager uses the seal of the proprietor. My lord, whether this statement nowhere says that he has not been authorized to do so. This is their inference. What he is, to the extent it is, my lord, profitable to the investigation, they record it. They do not record a statement, rightly or wrongly, that he does not have the authority to transact all these things by means of any, my lord, power given to him, or to use the seal of proprietor. Now, my lord, kindly come to Amit Sarkar. Where Amit Sarkar's statement we will examine, my lord, vis-a-vis his statement made in the writ petition before your lordship, how he describes. Mindly, my lord, kindly come,
Page 37.
page 37. And these are all post, my lord, 2018 when the writ petition was filed. 37. My lord, Amit Sarkar so and so. See, Amit Sarkar alias Lanu Sarkar stated that so and so is called Lanu because of the name given to him so and so. He is doing business in the name of his wife. So and so. She is, my lord, petition number 2 here. My lord, nobody has come to tell that either this is a lie or that he is not one of the proprietors. He is doing the business in the name of his wife. There can be joint proprietors, my lord. There is no denial anywhere to the statement made by me or us before your lordships on oath. There is no either suppression or, my lord, misrepresentation. He also stated the Kodani Enterprise and so are in my wife's name. Maybe for any purpose.
Mr. Day, I am testing this in the view of a 161 statement, which is not admissible. There's no quarrel on that. But the fact that the person, the petitioner number 2 in the other writ petition, signed as the proprietor,
He signed as a proprietor.
is the question before this court, which irrespective of these, is the fact.
My lord, I as the proprietor have not disowned him. Can the police disown me? What has gone behind is not the story before this honorable court, and I'm sure your lordships will not trouble this honorable court. What goes behind his using the seal of the proprietor for some transactions is between me and my employer, my lord, or us and the employer or the firm of the employer. The firm is not disowning him. Who is my lord to come and say that I have made a misstatement before this honorable court? Only because in some transaction, admittedly, the seal of the proprietor was used by my own manager. Do they have anything to show that he was not in any manner authorized to do this? That cannot be my case, my lord, in a criminal case. They have to run on their, my lord, like lack of jurisdiction cannot be repaired but by my lord, any statement or other things. Similarly, my lord, their charge has to stand on their own feet, not on my statement before any court or any other. My statement before your lordship has to be sanctified, my lord, on its own strength. There is no denial anywhere by anyone that we are not the proprietors. What they come and say, Kodaksara Venu, in spite of telling that he is the manager, has used the seal of proprietor. My lord, Kodaksara Venu, before your lordship, has given the same statement. He is the manager. In
He's
the
not
written-
giving the statement. He has stated out here that he's not the proprietor. He says that he's the manager.
He is the manager. And in fact, he is the manager. my
But
lord.
on the other hand, he signed the tender papers as a
My
proprietor.
lord, that is their case. But my lord, before the police also, he says that he is not the proprietor. Kindly see page 31. There's the front, my lord, there's the first sentence. I am not the proprietor. How he uses a proprietor seal is a matter for the police to examine. But my lord, before your lordship also doesn't say that he is the proprietor and he uses wrongly. I also don't say, my lord, that my seal of proprietor has been misused by so and so. It is for the police, my lord. Before your lordship, he comes and says, I am the manager. My lord, the paper given by them, there also he comes and says, I am not the proprietor, I am the manager. Yes, he uses the seal of proprietor. Under what circumstances? It is not shown by the police, my lord. Merely because he uses the seal of proprietor, and that also I am not disowning it. How does either my statement before your lordships in a writ petition get vitiated? My lord, their case is that of misrepresentation before your lordship. This man comes and says, I am the manager. Before the police, he says, I am the manager. They bring up a case which they are yet to prove that in some papers he have put up the seal of proprietor. He might have, he might not have. That is not for us to decipher here. He might have, he might not have. He might have under the valid oath, under a valid, my lord, attestation, under a valid, my lord, attornment. These are not our matters. My lord, whether Kodapsala Venu had
No,
made
the
a
question arises. You had nothing to do out there. You had a proprietor has signed a particular document. It is that proprietor who would be
I
responsible.
say I'm the manager of the farm, my lord. I say I'm
Have
the
you
manager.
stated out here that your manager had signed it as a proprietor?
My
in
lord,
your petition?
in fact, before the police also had signed that, including check also was received by me.
Understood, but have you mentioned anywhere in your petition that
In the petition, there was no
that you
occasion
did
for
not,
me.
you were not the person?
My lord, in the petition, there was no occasion. They never told that I'm not the manager and I've misrepresented.
No,
I'm the
you are
proprietor.
challenging a transaction in respect, you are challenging an investigation being carried out in respect to a transaction. Saying that you are the proprietor of that particular firm.
No. My lord, let me just verify. There are two petitions before your lordships. In petition number 174, husband and wife comes and says that they're the owners. Before the police also, they say the same thing. In the second petition, the firm and its manager comes and says the petition number 1 is the firm, petition number 2 is the manager. Same is the statement before the police. Now, my lord, they pick up a charge sheet yet to be proved. They say that they found some evidence to show that in some papers, this Mr. Manager has represented himself as a proprietor. How does it
No,
vitiate?
in respect to this, why it becomes important is because of the fact that both of you have come, the petitioners in the first petition comes before this court, challenging an investigation being carried out in respect to a transaction wherein some A has signed as a proprietor of another firm.
No, not another firm, this firm.
Understood. That transaction is in respect. What is the transaction where an investigation is being done?
My lord,
An investigation is being carried out in respect to a tender submitted by this particular firm. Saying, and that investigation says that look here, the amount should have been around 6 crores or 7 crores, but it has
9
been
crores,
changed
they
as
say 9
14
crores,
crores. And as such, we are starting an investigation into this.
My
You are
lord.
challenging that who are they to investigate?
My lord.
We are
My lord.
nobody to
My lord,
investigate.
yes. I'm completely clear. My lord, misstatement, if any, has to be, my lord, misstatement is very dangerous term, my lord. Perjury, not only dismissal, perjury. My lord, my crux of submission before a lordship is to say that I am a private citizen. Misstatement, my lord, a statement will be a misstatement if they come and show I am not a private citizen. I am a private citizen of any status. I have misrepresented as an owner, I have misrepresented as a manager. That will not denude me of my status as a private citizen, which is the crux of the matter here. My sole argument is before your lordship, they would not have proceeded against me because their power of investigation is limited only to public servant. I am admittedly not a public servant. I am a, my lord, private firm's owner or manager, whatever. That does not denude me of my lord, right as a private citizen vis-a-vis the investigation, which is the crux of the matter. My lord, misstatement will be a statement which shows, my lord, my entire stand before this honorable court on the basis of which I come is, my lord, something, my lord, fraudulent. It is not the question of owner or manager. It doesn't change my locus before your lordship. When your lordship decides their, my lord, jurisdictional part, it does not denude me of my cloak of a private citizen and not a public servant. What they are now trying to say is, this man being the manager is using the seal of a proprietor. It's a different matter. He might have used the seal of a proprietor. How he is using the seal of a proprietor, or have you ever put the question to me, the owner, Mr. Amit Sarkar, a wife, that Mr. So-and-so is putting the seal of a proprietor? What is this? These are not there. So under what circumstances he has used the seal of a proprietor? Using the seal of a proprietor per se is not illegal, my lord. Nobody is, my lord, question that they must have told before your lordship, before, my lord, quote unquote, using the term misstatement in a writ code is, here is a person who is putting up the cloak of a private citizen and telling that this investigation under law could not have been proceeded against a private citizen. Look, my lord, he's a public servant. And this cloak is a fake cloak. Kindly, my lord, lift the veil and see he's a public servant. That's a misstatement. Not, my lord, their case in a charge sheet which is yet to be proved that he's using the seal of a proprietor. My lord, he might have used the seal of a proprietor. That's between me and the manager. That's not the subject matter of writ court, my lord. Misstatement. A statement will be a misstatement in the parlance of this petition if he comes out with a prima facie proof that, look, he is telling that he is not a public servant, hence is not within the gallows of this department. Look, my lord, he has made a misstatement. He is a public servant. That's a misstatement, my lord.
No, I understand. Your submission is the misstatement, if it is material for adjudication, then in that case, that would be construed as a mistake.
My lord, it must have the value of misguiding an honorable court.
Or just for example, a suppression of all facts is not, would not denude this court from exercising the jurisdiction under Article.
Your lordship
It is
used the
only
word
the suppression
material.
of material.
Suppression of not
Material.
fact, material fact. This is not material. And my lord, these are matters which are disputed in nature. They have to prove it in a court of law. Whether at all they could have submitted it, that's under question. And the only standpoint is private citizen, public servant. And my humble submission, when it the stake of repetition, my lord, neither the Vigilance Commission's power nor the, my lord, Lokayukta's power transgress that barrier. They do not embrace a private citizen. And my lord, under Lokayukta, there is a further bar. They cannot take up any matter which is covered under entry C of Schedule 2.
Action taken in matters which arise out of terms of a contract governing purely commercial transactions of the administration with the customers of the supply.
It is actually the other way around.
Except whose or the complaint alleges harassment, gross delay in meeting the contract.
Except whose or the complaint alleges harassment of gross delay in meeting contractual obligation. It is, my lord, in common parlance, probably aimed against an officer who delays my bill. Probably that man. The entire subject is now under bar. My lord, a repeal clause is not matters, but still, a repeal clause cannot reread or, my lord, enhance the scope of statutory power given to a organization. It's a repeal power, my lord. Repeal that organization will become defunct. So you take over. My lord, when I take over under section 36, all inquiries and investigations will naturally be investigations and inquiries which are permitted under law. My lord, my humble submission is in the initial stage itself, it is not permitted under law. So section 36C will not come to their aid. In, my lord, derogation of section 8 and 9, which are the crux of the mandate of the legislature.
So you mean to say that the charge sheet at best can be recommendatory? Nothing more than that.
My lord, at least in my case. In my case, they can't even file a charge sheet. And how can a charge sheet be filed before a court, my lord? It's recommended.
Yes, Mr. Jamin.
Also, one,
Veracity of the charges, my lord, I know your losses will not put me a question because it's not a
more on misrepresentation. Para 17 of the writ petition, page 10. And your lordship, when it comes to the status of the petitioner, your lordship, that in my respective submission will be material facts, your lordship. The petitioner must come before this court and be clear about his status and standing, your lordship. Page 10, para 17, your lordship. My lord has got it. That whether the material supplied and installed by the petitioners through their firm through a valid multi-bid national tender. I will take this in two parts. A valid multi-bid first, and then national tender. I will come to that next. On multi-bid, your lordship. May I again take your lordship to IA, page 20. The IA I will be referring from time to time, charge sheet, your lordship.
Yes.
Page 20, your lordship. Now, third para from the bottom, tender documents. My lord has got it. Tender documents reveal the details of the tender, which is as follows. Number one, tender is Courtney Enterprise, contractor and government supplies, whatever, proprietor, Kedusulo Benu. Second tender is Nile Enterprise, government contractor such and such, and Nile Enterprise is proprietor is the petitioner, number one's wife, the petitioner number two in this petition. And tender number three is Syntax Medical, proprietor D.I. Solo. D.I. Solo, your lordship, is the gentleman who engaged Kedusulo Benu to be the proprietor of MS Courtney Enterprise. So this is the multi-bid tender, your lordship. So next line, investigation, however, revealed that the above three firms belongs to Amit Sarkar alias Lanu Sarkar. So this again is misrepresentation, your lordship. There was no multi-bid. The three bidders owned by the petitioner number one, your lordship. And coming to national tender. May I take your lordship to page 35. Serial number 3, he is the accused number 3, and he was such and such joined. He was then the deputy director. Dr. such and such, while serving as deputy director, NHR admitted on such and such that there was no NIT call for procurement. Forget about national tender, it was not even a local tender. No tender was floated. The three firms who have submitted the bids belongs to petitioner number one, your lordship. So the statement made in the writ petition, And Your Worship, as I've said, when there's separation of facts, Your Worship, the Honorable Appellate Court has held that, in fact, dismissing the if the petition is not dismissed, it will amount to failing the duty of the court, Your Worship. Just may I take Your Worship to one case law 30, Your Worship? 2008, volume 12, SCC, 2008, volume 12. I have supplied the list of books, page 481. 2008, volume 12, SCC, 481. Para 34, 35, 36, 38, and 39, but I'll read only para 34 and 39. Para 34.
Yes.
My Lord has got it. The jurisdiction of the Supreme Court under Article 32 and of the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned there are issued for doing substantial justice. It is, therefore, of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merit of the claim. Para 39, Your Worship.
Yes.
If the primary object as highlighted in such and such is kept in mind, an applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hand. Suppression or concealment of material facts is not an advocacy. It is a jugglery, manipulation, maneuvering, or misrepresentation, which has no place in equitable and prerogative jurisdiction. If the appellant does not disclose all the material facts fairly and truly, but states them in a distorted manner and misleads the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the lunacy and refuse to proceed further with the examination of the case on merits. If the court does not reject the petition on that ground, the court will be failing in its duty. In fact, such an applicant requires to be dealt with for contempt for such and such, Your Worship. So in my respectful submission, Your Worship, the petitioner for this local court has not approached this court with clean hand, Your Worship. In fact, misrepresentation, suppression of facts is writ large. So in my respectful submission, Your Worship, even without going into the merit of the case, this petition needs to be dismissed. The threshold.
Yes, what do you say about the jurisdiction part? What he
Now,
is trying-
my second, I'll be coming to that, Your Worship. Second, Your Worship, just preliminary submission, in connection with the RC case 10 of 2017, which is under challenge, Your Worship. During the pendency of the petition, charge sheet has been filed, which has been also placed on report by the petitioner by way of filing IU 149 of 2023, Your Worship. Now, with the filing of the charge sheet, Your Worship, now, in fact, Lokata has investigated, and then it already filed before the special judge, Your Worship. And the charge sheet is not under challenge.
Mr. Jamie, recently various judgments have come by the Supreme Court that when the initial FIR is being challenged out there, subsequently a charge sheet is being challenged, filed.
Lordship,
This court can very well take over.
Lordship.
That is not an issue. Otherwise, I would have troubled Mr. Dev with that question earlier.
What I would like to press upon Your Lordship is that, like, whatever ground is taken by the petition in this petition can be taken before the special judge on jurisdiction, Your Worship. That is my submission, Your Worship.
Understood,
And-
but when the matter is before a legal point is being raised before this court, can its court just shut its eyes and say, no, go there?
Lordship, then I may be allowed to come on merit, on jurisdiction. Now, Your Lordship, jurisdiction, the issue has been raised by the petitioner in para 22 and 23, which has been brought to the notice of your worship, where the resolution is there, how Vigilance Commission was constituted. And your worship, I have also taken place before your worship the notification where the officer in charge of the police station, the notification.
Yes.
So all the three notifications which I have taken your worship. And then you're investing the power, to the Vigilance Director of Vigilance Commission to investigate into offenses relating to the PC Act, Prevention of Corruption Act, and also under relevant provisions under the IPC, your worship. That is 21st August 1999. And I've taken I've also placed before your worship. Judge. There's another 23rd March 2007, special judge appointment. It is there, your worship.
Where, fill it out. This is only is pleased to appoint the tribunal for disciplinary proceedings.
So in the Vigilance Commission under such and such, and then any offense punishable under the PC Act, any conspiracy or permit, what it is.
So. a
Now, your
private
worship,
individual
so
can be blocked.
in my respectful submission, your worship, in view of the power invested upon the Director of Vigilance and Anti-Corruption, your worship, no illegality has been committed by the Director of Vigilance and Anti-Corruption, your worship, in registering the case RC 10 of 2017, your worship, and investigating the matter against the petitioner, your worship. And on the issue as to whether a private individual can be investigated under the PC Act, your worship, we'll just rely on one decision, 2003, volume 8 SCC 628. Worship has got it. I'm relying on para 1, 2, 14, 15, and 17, your worship. May I read out para 1? In this appeal by special leave, the core question which arises for consideration is whether the appellant herein can be charged and tried together with the other two accused by the special judge under the provision of the PC Act, in view of the fact that the appellant herein has been charged only under Section 420 IPC and under Section 120B read with 420 IPC, while the other two accused have been additionally charged of the offense under Section 13.2 read with Section 13.1D of the PC Act. The appellant contends that the special judge under the PC Act has no jurisdiction to try the appellant, who is not charged of any offense under the said Act, that is PC Act. While the respondent contends to the contrary, relying upon the provision of the said Act and the CRPC, the High Court of Bombay, by its impugned judgment order, has answered the question in the affirmative, holding that the appellant can be tried by the special judge under the PC Act, along with the two accused who also stand charged of the offense under the Act. The facts, your worship, para 2. Before adverting to the submission urged at the bar, we may very briefly notice the broad facts of the case to appreciate the nature of the allegation made against the appellant and the other two accused. Accused number 1, such and such, was at relevant time the manager of the commercial branch of SBI, such and such, while accused number 2, such and such, was an accountant employed in the same branch of SBI. The appellant herein is accused 3, who transacted business with the said branch of SBI on behalf of 8 companies with which he was associated. There is considerable controversy as to whether the appellant was a director of those companies or whether he was simply representing them as the representative. This, however, is not of much consequence in this appeal. The case of the prosecution is that the appellant entered into a conspiracy with the aforesaid officers of the bank to cheat the bank. A clever device, rather intricate in nature, was conceived by them whereby 8 separate accounts were opened in the name of the companies concerned, and overdraft facilities was extended to the companies on the representation of the appellant and with the assistance of the
Mr.
aforesaid.
Jamil, I have read that. Paragraph
Right.
14 also I've read.
Yes,
But the issue out here, which has been addressed by the learned senior counsel for the petitioner is, if you see the constitution of the Vigilance Commission, more particularly section 2 or clause 2 of that commission, with the office number, would show that there are certain powers which are the same notification categorically delineates what is the jurisdiction of the State Vigilance Commission. It only says when it can be done only against public servants. So under such circumstances, would it be that an investigation can be carried out without, in terms of section clause 2, against a private individual, or would that be only recommendation in nature? That is the submission.
that was the issue here, Your Worship. In fact, this relates to the trial by special judge.
No,
Whether-
that was the case out here where there was a allegation against the other persons.
Yes.
Wherein those persons were under the PC Act. And here against him, this allegation of 420 is there.
Yes.
His specific submission was that, look here, there cannot be an allegation against me under section 3 or of the Prevention of Corruption Act. So how can it be done? So it said that in view of the powers given under 223 of the particular of the CRPC, why can't the special judge decide that? Let us not go to the special judge. We are still at the first initiation.
Your Lordship, my submission. The same principle should also apply when it comes to investigation. Now,
But the
offense-
fact is, Mr. Jamil, the investigation has to be on the basis of the resolution. The investigation power which is being given initially on the basis of the resolution, unless you say that the resolution has further been taken care of by this notification of 99, by which it has become, but it does not say anything else. Now, you see, let us not go to the special judge till now. He is on the question of how could you have initiated against me? It could have at best have been a recommended, that they could have recommended that look here, this person concerned was there along with these people, and as such you carry out an investigation and do whatever. But if it is only as regards a public official out there, you could have done so. Yes, I understand your submission to that effect. Why not the same principle which have been given in this case be implied also to investigation? But can it be done so, taking into account the resolution makes it very clear that we'll have the jurisdiction and powers in respect of all matters enumerated herein below, namely to undertake an inquiry into any relation in which a public servant is suspected. Now, to cause an inquiry or investigation to be made on any complaint that a public servant has exercised or refrained from exercising his powers for improper or corrupt purpose. This can be done so as regards a public servant. Now, his basic case is as to whether the investigating authority could have gone ahead in respect to private individuals.
The subsequent notification, Your Worship. Because subsequently, again, from time to time, they've invested with more power, Your Worship, the Vigilance Commission, Your Worship. I've taken Your Worship to this notification where a director of Vigilance and Anti-Corruption has been given the power to investigate into offenses under the PC Act, Your Worship. Now, if under PC Act, under the PC Act, the Director of Vigilance and Anti-Corruption, Your Lordship, they have power to investigate. They can investigate even not only public, because here, Your Lordship, the accused person, there are three accused persons, they are public officials, and accused number 4 is the petitioner. Now, if the offenses under which like they are charged for, be it under IPC Act or IPC, Your Lordship, if the offense is committed in the course of the same transaction, that is what Vivek Gupta says, Your Lordship, then even against private individual, it can be investigated because conspiracy is there. Your Lordship. This is a case of conspiracy. If the offense is committed in the course of the same transaction, that even private individual can be investigated. And in the Vivek Gupta, they said even the special judge can try private individuals. Along with, of course, there should be public officials. They cannot be only private individuals. The element of conspiracy is there.
But therefore, while dealing with the FIR, here, see that page 32, the petition. See the first paragraph. Based on the preliminary investigation conducted by so-and-so DSP, the case is now converted into a criminal case to cover the involvement of private individuals as well as government officials in the commission of the offense.
And if, Your Lordship, it is the case of the petitioner that yes, has no authority, cannot submit charge sheet, at best it can be common. The charge sheet is not under challenge. Now, how the petitioner is involved along with the others is clear from page 33, the charge sheet. Page 33, Your Lordship. May I read out?
No, Mr. Jami, I would not like to go into those.
Yes.
allegations, because that would not-
Then, Your Lordship, may I come to the second schedule, which has been relied upon by the petitioner. Clause C.
Yes.
Clause C to the second schedule, Your Lordship.
No, show me before that I've understood, but show me before that, what is the power of the Lokayukta to submit the charge sheet? I've seen as regards this, it becomes too. So this was done, the charge sheet was submitted recently.
No, yes, yes.
So recently it must have been done because now they have done, because at that point of time when.
Charge sheet is dated 19th July, I think, if I'm not mistaken.
Just 21. So this has been done by the Lokayukta. Couldn't have been by, because that already that commission has already, with the coming into effect of the act, that commission is no longer there.
Supposing maybe and Directorate of Vigilance and Anti-Corruption was established by resolution, some legal infirmity, or in fact, the constitutionally may also be questioned, Your Lordship. But now it stands validated, whatever action is taken by passing of this act, Your Lordship. That is.
So now
Now,
the investigation is being carried out in terms of 36(3)
yes,
of the Lokayukta.
local.
Now, once it is being done under 36(3),
Carried forward.
would the investigation now be effective by the second schedule?
I'll be coming to that. Your Lordship. May I take Your Lordship to second schedule? Second schedule. It says, see section 9(1)(a). Now, Your Lordship, interpretation. Schedule cannot be read in isolation, Your Worship. It must be read with the main provision. 9(1)(a). What does it say? Except as hereinafter provided, the Lokayuta or Upalayuta shall not conduct any investigation under this Act in the case of a complaint involving a grievance. This is very important, Your Worship. Complaint involving a grievance in respect of any action if such action relates to matters specified in the second schedule. Now, may I take Your Worship to 9(3). The Lokayuta or Upalayuta shall not investigate. This is the limitation period. Any complaint involving a grievance made after expiry of such and such. B, any complaint involving an allegation. So it emphasizes two categories of complaint, Your Worship. A says any complaint involving grievance for that limitation period is 12 months. Any complaint involving allegation, that is limitation is 5 years. Now, what is grievance? Complaint involving a grievance. Grievance is defined, Your Worship, in section 2(g). My Lord has got it? 2(g). Grievance means a claim by a person that he suffered injustice or hardship as a consequence of maladministration.
And complaint,
ma-
and complaint has also been defined.
Yes. Now, complaint means
a
a complaint made in such form as may be prescribed, alleging a public servant, whatever, under the PC Act. Now, may I take Your Worship for further clarity, section 10.
So the complaint has to be only in relation to a public Prevention of Corruption Act. It can't be anything else.
Your Worship, here,
That is why I think there is a different words
No.
used. Any complaint involving a grievance
grievance.
made after expiry of 12. That is grievance means a claim by a person that he has suffered injustice or hardship as a consequence of maladministration. Any involving an allegation made after. But both has to be in connection with PC Act.
Your Lordship.
In
Now-
the definition of section 2F.
Just for a moment, Your Lordship, and Your Lordship, this will be the first time that the jurisdiction, the issue of jurisdiction of Lokayuta is before this court, Your Lordship. So whatever Your Lordship decide, how Your Lordship interpret the second schedule, regular section 9(1)(a), it will lay down the parameters, the jurisdiction of Lokayuta, Your Lordship. Now, may I take Your Lordship to section 10?
No, that is why my specific question therefore is, let us assume the Vigilance Commission had the jurisdiction. Now, on the basis of that jurisdiction, because that is his second leg. First leg is doesn't have jurisdiction. His second leg seems to be that 2018 the new act is coming, 17 or 18. Now there is a bar by which the Lokayuta cannot go into matters pertaining to which are there in the Schedule B or Schedule 2. Now, whether the powers under 36(3), which empowers the Lokayuta to take over all the investigations which have been conducted by the Vigilance Commission, because there is no bar then in respect to those,
No.
can be further investigated upon in view of 9, in view of section 9 as well as this.
No, Your Lordship, this case does not come within the purview of section 9(1)(a), read with the
Schedule 2.
Schedule 2, Your Lordship.
Why?
Why, Your Lordship? Petitioner himself administered was an allegation. This is, and then it is not a grievance. And there's a distinction between grievance, Your Lordship may kindly see section 10 for further clarity. There's a clear distinction between complaint involving grievance and complaint involving allegation, Your Lordship. Section 10, Your Lordship. There's a fine distinction, Your Lordship, and subject to the provision of this act, a complaint may be made under this act to the law court in the case of an allegation by any person, and in the case of a grievance by a person aggrieved. Supposing if it is an allegation, it cannot come within the purview of the second schedule. What is barred under section 91A is only complaint involving grievance. Now, if all the complaints are to be barred, Your Lordship, the lawmaker wouldn't have, instead of using the phrase complaint involving grievance, they would have simply used the word complaint. But section 91A is very specific, Your Lordship. Complaint involving a grievance. Why not all complaint, but only complaint involving a grievance? So unless the petitioner can make out a case that his case is a complaint involving grievance, then second schedule will be attractive. The petitioner himself admits that there was an allegation against him, conspiracy, whatever.
So your submission therefore is that for
And
the section 2(1)(g) defines what is a grievance.
And Your Lordship, there is another category of jurisdiction, complaint, which can be investigated, Your Lordship. My Lord, may kindly turn, see section 35. Section 35 says that the provision of Anti-Corruption, Grievance Redressal and Whistleblowers Protection Act. Now, Whistleblowers Act will also apply, Your Lordship. Because look at the section 10 says that any action can be investigated. So Lokata can also now investigate complaint involving disclosure under the Whistleblowers Act, Your Lordship. May I now, what is the nature of complaint under the whistleblower?
Wonder, madam. I at times wonder how a human body endures the other side, my lord. Forcefulness.
This is a Whistleblowers Act, Your Lordship. May I take Your Lordship to section 3C, page 5. Pagination is at the bottom.
But
How-
this is 2011
To-
and the Whistleblowers Act we are giving is 2014.
This is 2014, Your Lordship.
And only see section 35.
Now, this is amended, Your Lordship. Section 35, 2011 is there, that subsequently it is amended. Now it is 2014, Your Lordship.
Where is the amended provision, the amended act? I think this is an amended act. This is also 2011. When have you amended this? You made it 2014?
No, in the act, look at act, Your Lordship. No, that is not there. It is 2011 is shown. But then 2011 is subsequently amended in 2014, Whistleblowers Act.
How can we take into that, taking into account that it is a legislation by incorporation?
The only thing is that instead of the latest one, instead of 2014, still 2011 is shown, Your Lordship.
So if you see the judgment in the case of Bangalore Development Authority, the question arose out there as to whether the provisions of the new Act of 2013 could have been applied to the Bangalore Development Act.
Subsequent
wherein it has
amendment.
been
Subsequent
categorically
amendment.
mentioned
Lordship.
that the Act of
Lordship.
1894 would apply. And some other act would apply, a Act of 1894. The Supreme Court categorically said that it is a legislation by incorporation unless there is an amendment to that parent act.
Obliged,
You
Your
could not have done.
Obliged, Your Lordship.
So how do I now bring in 2014?
But anyway, Your Lordship, But there's also another category of complaint which can be investigated by your lordship under the Whistleblowers Act, and that is in 3C, your lordship, just for this. 3C. Complainant is there. The lordship has got it. Complainant means any person who makes a complaint relating to a disclosure under this act. And disclosure is defined as an attempt to commit or commission of an offense under the PC Act, willful misuse of power or willful misuse of discretion by virtue of its demonstrable loss is caused to the government or demonstrable wrongful gain accrued to the public servant or to any third party. So read with this Whistleblowers Act, your lordship, in fact, there are three categories of complaint which can be investigated by the local your lordship. Complaint involving grievance, complaint involving allegation.
But where is the 2011 Act? There is no mention whatsoever about the 2011 Act. Because the earlier Act is the provisions of Anti-Corruption, Grievance, Redressal and Whistleblower Protection Act 2011. To go by that only. Unless you have amended the Lokaयुcta Act.
So in my respectful submission, your lordship, like it is not the case of the petitioner that this is a case complaint involving grievance and thereby second schedule is attracted. Petitioner himself admits that there is allegation against him. So this is a complaint involving allegation. So second schedule, the question of attracting second schedule does not arise. your lordship. Now, your lordship, another contention advanced by the petitioner is that the locator is playing the role of the prosecutor. How can locator be a prosecutor, your lordship? My respectful submission as invested with the power to investigate under the PC Act. Right with relevant provision 9
Now,
PC.
show me that in the provisions of that Act, the Lokaयुcta would become an officer, there will be an officer in charge. Like in the Vigilance, it is there.
Yes.
But can the Lokaयुcta exercise that power? Because in Vigilance Commission you have given, but the Vigilance Commission did not submit the charge sheet. The submission of the charge sheet is by the investigating officer. Can there be an investigating officer? The power given, let's see what is the Lokaयुcta power. Power of the Lokaयुcta is.
Yeah, read with 36, your lordship, 36.3, whatever power.
No, but then also it has to, yes, it can investigate, but does the, here the Lokaयुcta has to, can submit a charge sheet? But that is a very important consideration. If it is not there, unless you don't have a notification.
Now, as I've said, your lordship submitted, if at all, like, okay, locator can at best can submit this, make recommendation, not file charge sheet, your lordship. But that is not the issue before this court.
No,
Because
here
the charge sheet is not being challenged.
Whatever may be, you have, as of now, when the question is there, that there is a charge sheet before this court. And there is an IF which was filed for the purpose of staying a proceeding, which this court has
Yes,
not.
your lordship.
But
Now,
matters not subject to investigation, it can submit, but what can it do?
what the challenge,
Procedure in respect, let us see this, section 12. Shall in each case decide the procedure to be followed in making an inquiry and ensure the principle of the Lokaयुcta and in declaring the refuse to inquire and achieve the When you come to power, but the power has been given in, just for example, it will exercise the power of a civil court in the terms of it under 14.2. Then kindly see 14.1 says that they have the power of investigation or inquiry furnished may require a public functionary or any person or authority who in its opinion is able to furnish information or procedure, documents relevant to the investigation or inquiry to furnish any such document. Any proceedings shall be deemed to a judicial proceedings within the meaning of so and so. Now, if it is a judicial proceedings, then in that case, where is the question of submission? Means it is already
Maybe
decided.
So far as investigation is concerned, interpretation, maybe that affect the law.
But therefore, one,
Yes.
there is a difference out there.
Because section 13.3. Section 13.2, your lordship. Section 2. Provision of CRPC relating to certain procedures have moved to the apply to certain as usual whatever. B, a warrant issued under substance and for all purposes speaking, a warrant issued under, maybe for certain for warrant integration, maybe for that purpose. The CRPC applies. And going by the prayer and the repetition, your lordship, what has been challenged is the registration of the case and the investigation being conducted.
The investigation is okay.
Your lordship.
You may investigate, but what can you do at best?
So say if we can look at that at best can recommend, then it can, the filing of charge sheet, yes.
It can may only to give a recommendation for filing of a charge sheet at best, nothing more than that.
Your
That
lordship.
is what he is also submitting.
But that is not the prayer and the repetition.
We can, the court has the power to mold it. Because his submission is at best. Because one thing, if you seek FIR, that is why I'm saying, kindly come to page 32 of the petition, of the first petition.
And your lordship may kindly also take this aspect into consideration, your lordship. Once the power is given to investigate under the PC Act, now the PC Act, provision of PC Act will apply. So under the PC Act, CRPC will come, your lordship, if I'm not mistaken, your lordship. How investigation is.
Now understood, therefore, the problem arises is a Lokayukta has a power to individual, yeah, but does the Lokayukta has a, because that power which was given to the Vigilance Commission is no longer there as on date. As on date, that power which has been given to the Vigilance Commission is not there. What power is being given now, therefore, the question is, with the Lokayukta taking over, would the, and more particularly when there is a statute out there,
Apply, your lordship.
would the Lokayukta direct, therefore I ask, how there can be an SP? So how can there be an SP for that? The Lokayukta functions on its own, it may have its office, therefore it can, that day another matter, no, I took it up, that he can only, there was a recommendation being made. So in this case, after an investigation being carried out, it may make a recommendation. But where is the power of punishments? Kindly see, kindly come to page section 26. Initiation of prosecution. Without, even for that matter, if you see a person who gives a false information, let us see that also. When you see this, how it works. Section. Yes, section 12, prosecution for false. Even that punishment cannot be given. Here, if notwithstanding anything contained in there, whoever makes a false, frivolous, vexatious complaint under this act shall, on conviction, be punished with an imprisonment for a term which may. Now, who can take the jurisdiction or exercise the jurisdiction of conviction?
Lordship, just based on one report. And these are all notified in the Gazette. Your Director of Vigilance and Anti-Corruption, the Director of Investigation. So after Lokata came into being, Your Worship, so the power of Director of Vigilance and Anti-Corruption has now become Director of Investigation, Vigilance and Anti-Corruption Police to that of Nagaland Lokata Police.
No, but where is the power to file a charge sheet now?
That's the submission of the police after investigation.
It may
Yeah.
make, therefore, what can it do? How to exclude complaints against certain classes of public. How to delegate public function, public servants to submit property statement, how to state government rules. How to look at the You see, even a false statement, a false complaint, the Lokayukta cannot do anything. Just for example, you make a false complaint also, the Lokayukta cannot convict you. The conviction has to be by the court on a complaint made by the Lokayukta. So under such circumstances, can the Lokayukta submit the charge sheet? Where is the SP of the Lokayukta comes from? Isn't it, Mr. Day? Where does the SP come? Therefore, I put the specific
My
question.
lord, basic question.
Where does
Where
the
is
SP?
Where is the superintendent of police come from? My lord, I'm obliged. Naming of a particular station, my lord, that's a joke came in my mind. We have got it elimination as Salvation Army. Tomorrow I am sending him to front, my lord, to defend my borders. We have got a distinction of Salvation Army. My lord, the legislative intent is so clear. When it comes to, my lord, prosecution, it uses the word prosecution, and to what extent? When it comes to power to punish, then also, my lord, 22. And for rest,
Even it has the power of contempt.
yes,
Power of contempt. Now,
Contempt.
power of contempt, the Upayukta shall have exercised the same powers as contempt and shall have the effect subject to the modification. The reference herein to the High Court shall be construed as including the reference. Section 18 of the Act shall not apply to
Yes,
him. The
yes.
Upayukta shall be deemed to a court within the meaning of the contempt of
yes,
contempt.
yes. No, the legislative intents are so clear. It is not that, my lord, the legislature stopped at investigation just merrily. It has consciously done so and transshifts the power to recommendation only and only recommendation, not prosecution. Even if I don't contradict my learned friends, my lord, submission that
Section
I-
12, you see the procedure in the respect of investigation. how it is.
investigation.
The Lokayukta shall in each case before it decide the procedure to be followed for making the inquiry and in doing so ensure that the principles of, so it has the similar trappings of a labor code.
My lord, labor code, civil code for some purpose.
No,
even
no,
for
no,
someone's
not
warrant.
civil code. Labor code, arbitrator,
Arbitrator.
principles.
Yes,
So that is what they can, because the principles of natural justice has to be given. The Lokayukta may in its discretion at any stage refuse to inquire or cease to hear. The complaint is free. There are sufficient grounds for investigating as to demand other immediate. Now, after investigating, what will the Lokayukta do? That also I am not finding, Mr. Jamil.
Yes.
15, 16.
Act is silent.
No. That is not a
Recommendation.
section 15, 16.
Interim require. If during the
Section
course of
15.
preliminary inquiry or investigation under the Lokayukta or the Upayukta is prima facie satisfied that the allegations of the grievance against is likely to be substantiated either wholly or beyond, by report in writing, recommend to the public functioning concerned to stay the implementation or enforcement of the decision or act. to Take such mandatory implementary action on such terms. Any stage of the inquiry on under the act forwarded into a report to the competent year recommending to take action as may be nature to safeguard to prevent further act of misconduct. Now can you see 17? The lokaयुक्त or upalokaयुक्त in addition to the officials of area may for the purpose of conducting a preliminary inquiry or an investigation utilize the service of any officer of area agency of area with prior information to the competent authority of the government. Any officer or investigator of the central government with the consent of the government.
Confined to investigation.
But whatever the investigation, there is only the question is recommendation. Then,
On filing of charge sheet, I admit your worship, act is silent.
so under such circumstances, the charge sheet which is being done, I think the local will take its call. I think they're better.
And the recommendation. And yes.
I don't want to set aside that. On the right, because of the word used there in the FI. One word, that is why I'm saying, kindly come to page 32 of the FI. Page 32 of the writ petition. Starts with the line after the FI down below, it's first line itself. It's a criminal proceedings in view of private and government officials. That is enough. For that investigation, but at best, what he can do is, Lokaयुक्त could have submitted a recommendation. On the basis of that, the authority should have taken the recourse to law. Isn't that, Mr. At the end of the discussion,
At the end of the
after spending 10 towards 14 minutes.
My lord, because I have been already in this. I've been right to the county. And now they cross the limit by 5 minutes.
So that cannot be considered to be a charge sheet. And the charge sheet at best, they can make a recommendation. And now can we treat that to be a recommendation? No, because it has to be under the signature of the Lokaयुक्त. Not the SP. So it has to be, whatever it can submit a report.
Lordship,
And on the making a recommendation, the state will take its course.
obliged.
I think the best option.
He can even grant sanction. But in the matters of PCA, he can even grant the sanction.
That is.
All that is also there.
No, you see,
No prosecution.
Mr. Day, one thing, whatever the allegation is against you, I'm not saying about you, against the public officials, this court is not going to touch on that.
We are-
So
They are
under
not there.
such circumstances, the only thing which relief you can get is that cannot be construed to be a charge sheet.
Lordship.
So the Lokaयुक्त has to therefore give a recommendation.
My prayer is limited only to my clients. Doesn't relate to public sector.
I am not on that. I should only say that whatever investigation has been done, not touching on that. Only thing is, it has to be construed as a recommendation. Or he cannot file a charge sheet. The only thing is that Lokaयुक्त can make a recommendation and it will be left to the Lokaयुक्त to do the next best. Why should I say more than that?
That power can be exercised, whether it is legally justifiable or not, that is my perception. I will. Because Lokaयुक्त has not done anything.
And now why is the bail application there?
My lord, because they wanted to arrest me.
Anticipated.
They wanted to arrest me. They wanted to, my lord, first of all, they won't give the FIR. They wanted to arrest me. In fact, my lord, this, my manager was late to sit for nights together. When it was pending,
Now what to do with the bail?
they cannot, one thing has to be very sure, my lord. They don't have any power of arrest.
Hmm?
They don't have a power of arrest. Neither the vigilance nor these people.
Vigilance is no there,
Vigilance
no
not there.
longer there.
So my lord, probably has to be allowed, my lord, in my humble submission, stating that you don't have a power of arrest. You don't have a power of arrest. My petition may become infructuous also. It may be dismissed also. But if it falls from your lordship, my lord, you show from the act where can you arrest.
In fact,
And under these circumstances, when yes, my lord, admittedly cooperated with your investigation as a private person, because a private person is obliged to cooperate with the investigation. It is another matter whether it can be investigated against.
Because Mr. Jami, earlier, the Vigilance Commission could have arrested him. Earlier, they could
By
have.
some pretext.
No, they could have earlier, because the power is given, officer in charge to everything. But now it is not there. No, don't leave everything to
in
me.
fact, investigation is over now. I think that is
No, no,
the-
investigation is not over.
it's on.
You will make a recommendation, which you may only recommend that you need to file a charge sheet or whatever may be, you may.
Yeah, so far as Lukate is concerned, Lukate is concerned.
To
that
safeguard, to prevent further acts, or yeah, to prevent, you may make a recommendation to the police, the government to initiate any inquiry or investigation.
What I mean to say is that, your worship, so far as Lukate is concerned, investigation is over. Whatever finding is there, now we recommend. Once it is, it has become sort of a functus official now, so far as RC10 is concerned, your worship. Now,
So under such circumstances, RC10, on the basis of RC10, he cannot be arrested.
by Lukate, I don't think so, your worship.
Then
Because
who is going to arrest?
And then that has been
No,
one
why am,
issue.
why am I worrying on that, not on the other? If a person is being given an anticipatory bail and made absolute, it not only becomes an anticipatory bail for further proceedings until the trial is over. Now the question is, if it is only a recommendatory, an investigation is required, then what will happen if he doesn't cooperate in view of the anticipatory bail already given?
Unless appropriate authority issues on
Therefore, what to do on that? Otherwise, there is no problem if it was that only. But tomorrow you make a recommendation, and if I grant a bail only on that, can it be construed to be a grain?
But making it absolute, but there should not be a bar for that.
How can I make it absolute? The moment I make it absolute in this connection, if tomorrow if you investigate or do anything also, tomorrow he will not come to you. He will not bother because the High Court has given it.
They can call me.
No,
In fact, can they even call me?
no, why not? Tomorrow, if a recommendation is being made and the police starts the investigation,
Yes.
Yes,
then,
yes. My lord,
Yes.
that-
then in view of my bail, if I am giving you, you would not come. Why?
No, my lord, then RC10 will no longer survive. This RC10 will go, my lord, my bail is only.
RC, no, it is on that aspect of the matter where this court has already granted you an anticipatory bail in total. Then,
Anticipatory bail in respect
So
of a
it all-
particular
they-
case.
your anticipatory bail has become infructuous now, therefore.
My lord,
In view of what I will say in the writ petition, the anticipatory bail application has become infructuous, and consequently, investigation will happen.
Yes.
If there is a recommendation, and subsequently, if anything
Yes.
happens, that will be
Yes, your
Yes.
worship.
fresh cause. So the anticipatory bail, I have to hold it as infructuous.
Infructuous, worship.
Because granting a bail here, he would never come.
my lord,
If made absolute.
my lord, the purpose for which your lordships were pleased to secure my life and liberty, my lord, that purpose has been achieved its end.
That I'll do it, but only thing is this, because I can't make it absolute.
Lordship.
Because if I make it absolute, there.
My lord, your lordships didn't let me. Nay, my lord.
No, no.
Infructuous.
Mr. De, you are a senior counsel, you also understand, the moment I make it absolute, it becomes, he would never participate in an investigation subsequently then, because this is, we will say, tomorrow you may not be here, somebody else will be there, then he will say that this is a continuation of this. I have already got it. See, the Supreme Court says. Okay, I'll dispose it of today
Right.
itself. They dictate it, but what I'll say is that they have, it will be only recommended, it is the power of the locator in view of the provisions of the act. And during the process, if it did not happen anything, and in the meantime, they are coming into effect of the locator act, the power is only limited to this. It could not have submitted a charge sheet. And consequently, anything done cannot be done. It will be left open to the locator to take action in accordance with the provisions. That's all.
And I'm limiting my prayer only to my petitioners, not against others.
I am not saying against others, I'll only say only against them. This will be disposed of, and the bail is, I'll make it infractions. Because now has become redundant. Taking into account it is only recommendatory in nature. And as of now, there is no proceedings under any criminal proceedings initiated in accordance with law.
And with petition 16 not raised.
Which one? The second?
No, no, raising it.
No, why not? Both are.
Both will be the same.
Why should I not press it? No, if they don't press again, if they don't. press
No,
again,
no, there is no charge frame against it.
Against whom?
Against the manager, the proprietor,
No,
manager.
no. See, the charge sheet goes. I'm only holding that the year will be recommendatory. So left open to Upalaga on the basis of the petitions.
my lord.
Item number 23 to 42, is it? Only. Three. Number 20. Rakesh Ranjan, na?
My lord, I forgot to mention, there's a bunch of, my lord, petitions. Both the parties want to withdraw.
Very well.
My lord, 6 to 7, there are numerous.
Six and seven. Connected
Numerous
IA.
petitions, including IA and WPCs. 1, 2, 3, 4 WPCs.
6 to
2 WPCs.
6 and 7.
6 and 7, my lord. 6, my friend Mr. Jimomi is the petitioner. I am for respondent number 6 to 15. And 7, I am for the petitioners. And Mr. Jimomi, I think he appears for 6 to 37.
Yes.
So all the parties are represented, my lord, government. Service disputes, my lord, we are trying to settle. I think it's partly settled also. We are not pressing the petitions, my lord.
Lord, item 6, I am for the petitioners. Now, the instruction I have received is this, that our grievances will be addressed. So may I be permitted to withdraw with liberty to approach again if still agreed?
what is your grievance?
Fixation of seniority, my lord.
Would be redressed.
Yes, I have been told that my grievance will be redressed.
I'm for the respondent number 5. In
That's the government?
WPC 168.
No, you are the government?
No, I'm for the private respondents.
Who is for the government? The person who is going to redress is not here.
In fact, there has been, my lord, a series of parties, both the parties with the government officials. And my lord, we understand, my lord, instead of fighting it out here, my lord, it can be amicable. It's a question of, my lord, drawing out a principle to which we are working on.
I can say that you will be submitting representations before those
It is already
authorities.
submitted and the government is insisting
So
on
you
the
will
matter.
await the outcome of the representation. Has your representations been considered?
Rejected in a sense.
Then, how are you saying now?
But I have been, that's the instruction that I have received.
My lord, both the parties are sitting in a party. Representations.
Who are you?
My lord, I am the petitioner in 7 and the private respondent.
Again, the private respondent.
I am the private respondent in 6.
All of you are private respondents, but
I-
where's the government to say that they are going to consider? Yes, madam, you are for the government?
My pleasure, Lordship, he have a personal difficulties. So
Who?
the state government, I'm appearing on behalf of KIPA.
No, unless the government says that yes, you are going to consider, then only this court,
At least my party
Then-
doesn't make this.
you don't want the liberty.
No.
Okay, then he doesn't want to. You want the liberty, then the problem will arise.
Still agree.
If still agreements,
My lord, even-
then it will be bench hunting.
No, no, my lord. No.
Yes, it is.
My lord, they had enough of litigation.
Now, understood, if you want to withdraw with liberty on the same cause of action, that doesn't remain. Therefore, unless you are going to represent before the authorities and the authorities are going to consider, then it will be a separate cause of action.
Okay, my lord, I can do that.
Then it will be a separate cause of action. Otherwise, it doesn't look fair.
There is a separate observation, my lord.
Okay, I can do that.
You are the petitioner.
Yes, ma'am, I'm the petitioner in 6.
In 168,
Yes, ma'am.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner in WPC number 168 of the 2022 submits that upon instructions from his client, that his client would like to submit a representation before the authorities concerned, and depending upon the decision, the petitioner would submit a representation before the authorities concerned, and rather than pursuing the remedy before this court. So taking into account the above, the instant writ petition stands closed on withdrawal. However, if the petitioner is aggrieved by any outcome of the said representation, the petitioner would be at liberty to approach this court. Mr. S.S. Day, the learned senior counsel representing the petitioner in WPC number 224 of 2022 submits that he has been instructed by his assisting counsel, Mr. Muazzamir,
Yes, ma'am.
that the petitioner would not like to further proceed with the instant proceedings. Accordingly, the instant writ petition therefore stands closed. I accordingly stands disposed of.
Lordship,
Yes,
Praying for Lordship indulgence, the Portrait Matters.
yes,
Which
I
has to
remember.
be considered today.
Your item is which item?
My lord, in the admission 1 in the supplementary list.
Okay. Let me just quickly finish up this
Lordship,
because
yes.
I will give precedence. Your matter and there is a list
In
of
fact, Mr.
part of
Joshua is
matters.
waiting
I'll
for the
need
whole
to
vote.
finish it. I'll finish up those.
Yes.
Lordship, if I may be allowed to mention hearing item, supplementary hearing item number 21, if it can be possible for a day, Lordship. Ilu Chabang.
Yeah, Madam, I may not have the time to take up those matters, taking into account that after I
Yes,
take
Your
his
Lordship.
matter and that motion matter of
Yes, Your
Mr.
Lordship.
Siti Jameen
Yes, Your Lordship.
and the series from 23rd 3 onwards. Because I'll dictate it in the court, it will take some time.
Yes, Your
Your
Lordship.
matter may not reach.
So if it can be possible for a day.
It would be. Let us put it as leftover.
Okay, okay.
Lordship, I would like to mention admission item number 12, Lordship.
Don't mention those matters. This matter is now going to be taken up.
Lordship,
We will look into it. Just wait. Yes. Item number 4.
For admission, item number 4.
Regularization.
Yes, Lordship.
Why? Why you have not been regularized?
Your Lordship, here the petitioner is approaching since as per the RDR reply, which was given by the department. the junior who were much later appointed than the petitioner were regularized. So the petitioner is bring on that ground, Your Lordship.
You joined when?
Your Lordship, me kindly see my page 13, Lordship. It's from serial number 6 to.
You joined in 1995.
Yes, Lordship.
Now 30 years is done.
No, Lordship.
Then how are you going to be regularized as per 17/3/2025, 2015?
Is Lordship, what I'm bringing before this honorable court is that, Your Lordship, there are so many juniors who were appointed much later than the petitioner were being regularized.
Understood, but whatever may be, as of now, you are not regular, you can't be regularized in view of the 17/3/2015, isn't it, madam?
Lordship, in their affidavit in opposition, they have stated that regularization was made on the basis of sincerity in performance. Therefore, Lordship, I've already filed my reply on that. Even the concerned department has also given that the petitioner is he is also sincere in litigation.
No,
Lordship.
in the affidavit in opposition filed by respondent number 1 to 5, it states as paragraph number 4, that the petitioner has been serving for more than 27 years, and there is no policy of the state to regularize the workforce fixed pay employee. As per the OM dated, all exercises and casual employees of the area who are enjoying scale of pay and have completed 30 years or more continuous service as on here will be regularized. Now you are not getting a scale of pay.
I'm in the scale of pay, Lordship.
Then it is apparent from his appointment order that he's getting a scale of pay, Annexure A. Yes, madam.
Lordship, yes, it is not denied that the petitioner has served the department for more than 27 years, Lordship. But however, as per the office that 17/3/2015 scheme for work charge and casual employees and revisions of pay or wage, it is stated that all existing work charge and casual employees of various department who are enjoying scale pay and who have completed 30 years or more continuous service, then they are entitled or allowed to be regularized by conversions of their boss into regular ones personal to them.
Madam,
Yes.
if you see Annexure 1 to his writ petition, it's an appointment order which shows that he is being enjoying a scale of pay.
Lordship, I filed an additional affidavit. Earlier, the affidavit was filed by one of my colleagues.
You have filed? And?
I filed additional affidavit.
Additional affidavit, yes. What did you say? Yes, now this makes sense.
Lordship.
This makes sense. You will be considered once you have it 30 years. Let it wait for 2025.
Your Lordship, my only prayer is that now regarding about the OM, we admit that. However, my Lord, my contention is that here the petitioners who were much junior to him.
I can't help you with that. That is a negative equality. I can't help you with that. You, as per the scheme, it is 30 years and scale of pay. You have already got your scale of pay. Wait for another 3 years, 2 years, 1 year. I will note down this and dispose it off, and thereby to consider once you get 30 years. Win-win for you also.
Okay.
Yes. The instant petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent authorities in considering the case of the petitioner for regularization. It is the specific case of the petitioner that the petitioner was appointed as a work charge S/assistant by office order number EE/TSG/F/CD/APT-8/1435-38 dated TSG, the 29th of March 1995, under the establishment of the SDO bracket PWD in the scale of pay of rupees 1150-30 of -1450 -30-1800-40-2120 per month, and all other allowance as admissible from time to time from the date of joining. Full stop. It is the specific case of the petitioner that the petitioner had rendered as on the date of filing of the writ petition 27 years of service. However, the petitioner have not been regularized, whereas the persons who were junior to the petitioner were regularized. It is under such circumstances the petitioner had submitted an application under the Right to Information Act and could gather information that the respondent authorities were regularizing other persons who have been junior, for which the petitioner has filed the instant writ petition seeking a similar treatment. Full stop. The record reveals that an affidavit in opposition was filed by the respondent numbers 1 to 5 on 8/12/2022. In the said affidavit in opposition, it has been mentioned that as per the OM dated 17/3/2015, the OM dated demand all existing work charge and casual employees of various departments who are enjoying scale of pay and who had completed 30 years or more continuous service as on 1/1/2015 would be regularized by conversion of their post into regular ones personnel to them. This court at this stage finds it relevant to take note of the OM dated 17/3/2015 and more particularly to clause I. Is this I? Page 5 of your affidavit? Clause I, is it I or J or H? Of clause 2, is it 2, I suppose? I go here. Madam, page 5 of your affidavit.
Yes, Worship.
In respect of those work charge and casual employees in the scale area who had completed and will complete 30 years upon after remand, their cases of regulation shall be taken up subsequently in 2 batches on so and so. Now, this is, what is the name of the clause? Number of the clause? Yes, what is the number of the clause? I think it is clause 2. I've also taken note of the provisions of Iman of the OM dated 17/3/2015, wherein in clause what is that clause number? I.
Yes, DHIRTY. DHIRTY 30.
HI, this is I.
Lordship.
In clause 1I. Madam Advocate, Additional Advocate General, kindly see, is this I?
Yes, 30, your lordship, it's 30.
Yeah,
Yes,
it's I.
yes, THIRTY.
No, you see, 1H, then I. Is
Clause
it
1,
I?
subclause 1, subclause I.
Clause I.
This one, yes, your lordship, all existing work charge and casual employees of various departments who are enjoying skilled pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by a conversion of the post into regular ones personal to them and subject to.
No, 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 no,
fulfillment
not
of
that, not that, not that, not that. This is not that. The other one,
The other one.
what is that? G, is it two? One or it is two. One Roman two.
Okay.
One Roman two.
One Roman.
But I have
Yes.
also taken note.
In respect of those who are charged and casual employees.
It's one Roman two.
Yes, it must be your lordship.
One Roman two. I have also taken note of the provision, the office memorandum dated 17/3/2015, wherein in clause one Roman two, it has been specifically stipulated that in respect of those work charge and casual employees in scale of pay and who have completed or will complete 30 years of continuous service after 1/1/2015, their cases for regularization will be taken up subsequently in two batches as on 1st of July and 1st of January every year. The procedure and the terms and conditions would be same as laid down in the said office memorandum. Full stop. Taking into account the said office, full stop. Subsequent to the filing of the said affidavit in opposition, an additional affidavit in opposition was filed by the respondent state, wherein the respondent state duly had admitted that the petitioner herein was enjoying a scale of pay. However, the petitioner have not completed 30 years. Full stop. Paragraph number 3 of the said additional affidavit being relevant is reproduced herein under. Full stop. The said is reproduced. Full stop. From the above stand of the respondent state, and also taking into account the office memorandum dated 17/3/2015, it is apparent that the petitioner's case cannot be taken up for consideration for regularization until and unless the petitioner completes 30 years of service. Full stop. Taking into account the specific stand which have been taken at paragraph number 3 of the additional affidavit, this court disposes of the instant petition, thereby directing the respondent authorities to consider the case of the petitioner for regularization upon the petitioner completing 30 years of service. With the above observations and directions, the instant petition stands disposed. You are still working?
Yes, Lordship.
For admission, item number 5.
Yes.
Lordship. Lordship, I have just recently received the affidavit in opposition filed by the permit. Lordship, a week time may be granted to enable me to file my reply.
Compassionate appointment.
Yes, sir.
What is that? What is your number as per the affidavit?
As per the list of applicants, I'm in serial number 6 and number 4, my lord. And as per the date of that, I'm at serial number 8.
For appointment, chronological list of receipt for appointment, ground serial number 4, which is to maintain annexure for maintenance of petitioner's name is at serial number 8. Yes, what remains? You are at serial number 8. You will be considered. They cannot give you, this is the office memorandum. Nothing remains.
Lordship, a week's time maybe.
For what? Can you improve anything?
Lordship, to seek instruction from the client. As to
For
whether
what?
affidavit-
This affidavit was filed on 23rd of February. They categorically say that you are at serial number 8. You will be considered.
Yes.
Yes, Lordship.
The instant writ petition has been filed by the petitioner alleging that the inaction on the part of the respondent authorities in considering the case of the petitioner for grant of appointment on compassionate grounds, more particularly the office memorandum dated 17/9/2015. It reveals from the records that the petitioner it repeats from the writ petition that the father of the petitioner was serving as the upper divisional assistant in the Directorate of Agriculture, and while serving in the same capacity, he died in harness on 26/4/2012. It has also been stated that as per the government notification dated 21/2011, the services of the petitioner, the services of the petitioner's father was upgraded from UDA to Assistant Superintendent (grade 2) by the office order dated 29/5/2012. Pursuant to the death of the father of the petitioner submitted an application for appointment on compassionate grounds against the resultant vacancy caused by the death of her father. However, the petitioner's application having not been considered, the petitioner has therefore approached this court by filing an instant writ petition. This court has duly taken note of that an affidavit in opposition which has been filed, wherein it has been mentioned that the petitioner that mentioned that pursuant to the office memorandum dated 17/9/2015, an addendum was issued dated 9/4/2019, wherein clause number 11 was inserted to the office memorandum dated 17/9/2015. On the basis of the said addendum, it is the requirement that the roster list for appointment for compassionate basis has to be based on chronological order. Has to be.
Date of date.
Has to be as per the said addendum, as per clause number 11 of the office memorandum dated 17/9/2015 as inserted by the addendum dated 9/4/2019. The scheme shall be strictly in order of the date of death, and first preference shall always be given against those who have died earlier and who fulfills all other eligibility criteria. So, according to the respondents in their affidavit, it has been mentioned that the petitioner is under case is under consideration, and his
That's serial number 8.
he is at serial number 8. He or she? She. And she is at serial number 8. So, taking into account that the respondent authorities are duly taking steps for consideration of the petitioner's application in terms with the office memorandum dated 17/9/2015, this court finds no ground for issuance of any for passing any additional directions except directing the respondent authorities to consider the case of the petitioner in terms with the office memorandum dated 17/9/2015, as well as the addendum dated 9/4/2019. With the above observations and directions, the writ petition stands disposed of.
For admission, item numbers 8 and 9.
Before starting this, yes, madam. Not filed into the matter. These unauthorized contempt is there, madam. Contempt and the item number 9, madam. The responder 1 and responder 5 should be repaired, madam. And for responder 1 and responder 5, madam, know the guideline. This is regarding this is the award, madam, passed in 2012, madam. This related, madam.
Then,
madam, there what happened, madam, is the petition was filed, madam, against the order of the Deputy Commissioner Dimapur, Deputy Commissioner. What happened, madam, in this, the one award was passed, madam. Subsequently, the private respondent filed for enforcement of the award petition, madam. After it was reviewed by the department, my lord, review petition was filed, my lord, and it was also rejected. Then department filed a read petition. there is no writ appeal also dismissed, my lord. There is only one observation. Heard this matter, my lord, and we wait on another requisition, my lord. And in that case, my lord, there is observation was made to there is alternative remedy, my lord. So section 12 of the Nagaland.
Asking you to seek remedy under section 12.
Yes, my lord.
Now the question is, how can you seek a remedy? It is the
Yes,
person who is
Yes,
agreeing.
ma'am. Therefore, what happened, writ petition also filed, my lord. Writ petition was filed challenging the award, my lord. That was also rejected, dismissed by this honorable court, my lord. And it was, he observed the same observation also, that is the alternative remedy, my lord. This section 12, my lord. When we filed, when contempt petition was pending, my lord, and we filed it, taken before, the application, Dimapur, my lord. And as per observation of this honorable court, my lord, the section 12(2), my lord. When it was pending, my lord, we filed a writ petition before this honorable, and it was honorable court.
No, Mr. Mehdi, can you tell me one thing? An award was passed.
Yes,
An award was passed under the 65 Act.
yes, ma'am.
Okay.
Yes.
Now, as per the award, you don't have a right of appeal
Yes, ma'am.
or reference, seeking a reference.
Yes.
Taking into account that the award has been passed by the district collector
Yes, ma'am.
on the basis of because the district collector acts as an agent of the government.
Yes, ma'am.
Therefore, neither in the Land Acquisition Act 1894, neither nor out here, that provision is given. Now, thereupon, the only remedy out here was to file a writ. You filed a writ.
Yes.
The writ was dismissed.
Writ was dismissed on the observation that there is already remedy. Yes.
The writ was dismissed. Then you filed a writ appeal.
Not against, we filed writ appeal against the reputation filed by the private respondent. Subsequently, after dismissal of the writ appeal, we filed a writ petition. Writ petition was dismissed on the giving the observation that the defendants also observed that there is alternative remedy, section 12 of the Act, my lord. And this was alternative remedy, so it was not available. So the writ petition dismissed, giving cost of 50,000. Then thereafter, what happened, this proceeding was here, we filed as per the observation of the before Deputy Commissioner, my lord. That was when pending, we approached this honorable court, and it was notice was issued, and when we filed the judgment of the writ petition, my lord. It was pending. It is still pending, my lord. Still pending. So, my lord, this when Deputy Commissioner, my lord, after filing this writ petition, my lord, rejected our prayer. Against the election, we filed this petition. Earlier was so this is the case, madam.
Yes, I've understood, but where do you go?
Yes, my lord. Only this review is pending, my lord. Review is pending, my lord. This
I remember this matter is connected with that matter, which I am fixed, and she
That
got
rent matter.
she took time, 3 weeks.
That is regarding the rent before the acquisition.
I remember.
Yes. And Lordship here,
Yes.
yes, Lordship.
What is he
could-
asking for? Let me see. Setting aside payment as to shall not be issued, setting aside and quashing the impugn communication dated past the year. Now, is it permissible under section 12?
No, absolutely not.
Then how can we entertain the writ?
Because the observation was made, my lord.
So what? Can this court grant you the
That is what's,
confer a jurisdiction which that authority does not have?
No reference lies, my lord, by the beneficiary.
84 Supreme Court.
Yes, my lord. Yes.
84.
Lordship, I have
84.
Lordship, even in
Therefore,
Yes, ma'am.
normally an appeal that's on against an award, there's no appeal, you cannot challenge. But however, if section 12 is gone, but what will happen if there is a gross illegality being committed? Then if a writ petition is filed then, but with the dismissal of that writ petition, you should have filed an appeal.
If there's
Review is pending.
only on the ground of collusion.
Review is pending.
Oh, you told me last time, na?
Yes, my lord, review is
When I was sitting in court number 3, I remember.
pending.
And what has happened there?
What of the review was that, but subsequent on that day, it was segregated review from the review.
No.
But,
Reviews by-
without a review being done,
Yes, sir.
that, the district, there is no question of interfering with this order.
Yes, sir. So may I this come along with this review petition,
Again, earlier prayer was there, it was enclosed and then it was detached.
in another petition, my lord. Because
Lordship.
there was another petition, because for subsequent after rejection.
Lordship, if I may,
So may I pray this, now my lord justice.
Who detect the review petition from this?
My lord, as per their
no, Lordship, it is like this.
subsequently their.
Who detect it? Which order?
Review was
Order,
not-
my lord.
No, my lord, not review. It was never taken along with the review, my lord. It
It
was
was
taken
there.
along with the other, with the contempt petition, my lord, with the contempt petition.
Because his entire case hinges upon the order passed by the single judge.
Yes, ma'am.
Lordship,
Earlier.
if I may, Lordship, what was passed in 2012, they did not pay, so we came here, a direction was passed in a writ petition to pay the amount. They appeal against that, my lord. In the division bench also says you pay within this time. They went all the way up to the Supreme Court. They withdrew the receipt. So dismiss was withdrawn. Then they come back and file a writ petition. My lord, Lordship has rightly pointed out, unless collusion or some kind of corruption is alleged, if they cannot challenge the award. It was rightly dismissed. Some observation was made, my lord, saying that you have not gone under section 12 of the Act, of the Acquisition Act. But it was not that they were asked to go and file a reference. Lordship, that is not the case as it's being portrayed now. So after that, my lord, they were.
Where is the order passed by the single judge earlier,
Earlier, my lord.
which is the subject matter of review?
Yes, ma'am.
Lordship, may kindly come to,
It must be in the writ petition.
Lordship, it's at page 153, my lord, of the writ petition.
153.
53. 153.
Of the writ
No,
petition.
I'm sorry, of the writ petition. Lordship, that is
Yes, sir. I'm coming.
my.
Oh, yes, I remember this. Yes, I read.
Lordship, I filed
This is my lord from sir, page 56, my lord.
Lordship has.
56 to 60, my lord. Page 60, page 60. In view of the aforesaid decision, honorable division bench, and in view of the provision of section 12 of the petitioner having alternative remedy, therefore the present reference is not made.
65 Act, Nagaland.
I.
Lordship has found it, my lord. After that, Lordship, they have filed this application for reference. Lordship is rightly pointed out, my lord. The reference does not lie. Beneficiaries cannot. Section 50, Lordship is aware of the 65 Act, local act. And it, Mudadis applies, 1894 applies. Lordship. Under section 52, beneficiaries or the government, they cannot, for a right is not given, there's a bar. And that has also been.
That is true, my lord. I understand that.
A person aggrieved will be defined as per person aggrieved. Person interested, person having the same meaning of this. 1894 Act.
Person interested as well.
Person aggrieved by an award made under subsection 2. There is no word, the Act of 1894.
Yes.
The person interested is given.
Is there?
But person aggrieved will be whom?
Person aggrieved, person interested is being mentioned in 1894. Here it's the person aggrieved. But in under the local act, the word used is person aggrieved. Now, in 1894, the word used is person interested.
Therefore, if it is a person aggrieved by an award, now
But,
can you
Lordship-
see where there is a disagreement with regard to the compensation under subsection 3 on an application of the person entitled to the compensation requiring the matter to be referred away. Where in 11.2, where the compensation has been determined by the Gaya and the Imam, the collector shall make an award in accordance with the set principles and the Imam. Where only person agreed by an award and the Imam making an application. So person aggrieved, wouldn't it encompass the central government?
Yes.
Then it will be there, yes. Person interested also, maybe in one of the cases it said that so even the beneficiaries will be. But the right to go for reference, to make a reference, has been barred by section 52
Of
the 1894, which is.
But
also-
understood, but the fact is, if you kindly come to section 18 of the 1894 Act,
Yes.
who can go? See, 1894 Act. Because the reference is to be made under the 1894 Act by under section 18. Where's the section 1894 Act? You have it? What does it say? Read.
Which one?
Read
Section 18.
1894.
Section 18.
Section 18.
Reference code, any person interested who has not accepted the award.
Kindly see, any person interested. Whereas here the word is person aggrieved. If it is the person aggrieved, why can't he go there?
Any person interested. So
See, 1894 is categorically says if any person interested. And person interested are those persons whose land has been taken. You don't require, you have it with you. Yes.
person interested maybe. So this person interested are those person who are the owners of the.
Yes. But there's a definition of person interested in 1894 Act. Now here, the person interested has been defined as to mean the same meaning. But here the word is person aggrieved. Whereas 11B, the 12(1)B says something else. Where there is a disagreement with regard to the compensation payable under 11(3).
Yes.
This is only as regard requisition. Then the person entitled to the compensation. So the Act has differently treated person aggrieved and the person entitled to the
That I've understood. I've understood what your lordship is saying. There's A and B, there's a difference. Any person agreed by an award in the subsection. Lordship, what about 12(2)?
12(2) is what?
Subject to provision. Right.
12(2), where's 12(2)? 12(1), 12. Subject to the provisions of Trias shall mutadis may apply. Yes, how the reference will be? Reference, you see, then what will happen? They will go as per section 19, then 20. This is how the reference is done. How do you make the reference? The reference, he has to send the statement out there. The awarded statement to the civil court, and thereupon the civil court shall decide. This is section 19. So here the use of the word is person aggrieved. Be that as it may, why you are not making the payment? Why you are not making the payment?
Furthermore,
Whatever may be, you may be, as of now, you may have something to make a reference. Making a reference, does it make, gives you anything that you one day you will go for making a reference?
Lordship, furthermore, section 25 of the Act of the 1894 Act also says that the reference court cannot lower the award. award cannot be lower than what has been given. And Lordship, the division bench has already directed them to pay.
Then why you not paying? You have to pay. How much is the awarded amount?
Lordship, it's about 6 crores.
How much? 6 crores. For you, peanuts.
Only land,
Yes.
land below.
7 crores, 69 lakhs.
Oh, 7 crores. And who is going to bear the interest?
Yes, that is.
The interest is 9% and 15%.
And they're utilizing the land.
Our contention before Deputy Commissioner was, my lord, land was under lease from 1962, my lord. After 1984, there is a lease agreement, my lord.
For 50 years.
Retrospectively, my lord. And it was compared to 2012, my lord. In 2009, my lord, we approached the district commissioner, my lord, for further lease, my lord. Our prayer before is the further lease and of this particular land, my lord. But
By paying 600 rupees.
no, my lord. Not the one.
Yes, no, I know because that case I was taking into account.
That is not.
Because initially you were paying 60 rupees.
Yes.
And as what the government will charge.
But at that time, it was fixed 60, my lord.
So
Yes.
now now the next council who was appearing in that matter says, we are ready to pay 600 rupees. And he fixed it at 900 rupees per 1,000 square feet. And you are agreed by that.
But the market, they will entitled. So,
Are you saying that?
my lord,
No, are you saying that? I'll record it. Then obviously that will be a huge bonus for them in that case, which you are. On the other hand, the union is categorically saying that no, we are going to pay only 600 rupees per acre,
this-
not 900 rupees per 1,000 square feet.
same,
And that is your contention. And now you are saying this.
same case.
Yeah, I know that. This is the same case. Because that day the matter came up. Then you can't go this way, blow this way or that way. And there is a constitution bench judgment of the Supreme Court which categorically says that you can't keep a land for acquisition. It would be a fraud on the power. Then
Lordship, since the year 2000.
What happened, my lord, this land.
when are you making the payment?
My lord, I have to then.
Ask your person to appear on Thursday
My lord,
before the court. No,
Sorry, my lord.
ask the person to appear in court.
My lord,
This is not done. This is the case of contempt on the face of it.
Before the
Tomorrow.
my lord, I have some personal,
Tomorrow.
my personal difficulties also there, my lord. So.
I am Mr. Counsel, I am not bothered with the personal difficulties of councils. Here is a case out here where I am concerned that this is an order passed by this court which has not been violated by you, right and left and center. Then the matter goes to the division bench, the matter goes to the Supreme Court, you withdraw the SLP and now come up with all these things. You are to pay this amount. Who is the person who is going to pay? The DEO? Ask him to be present.
No, DO is not concerned.
Yes, the DEO.
No, madam, no. DO is not concerned.
Who is going to pay?
Here, my lord, the chief, my lord,
Who is going to? It is the DEO. The DEO pays.
No, madam. No.
Mr. Mehdi, Mr. Mehdi, I don't know many, I may not know many other cases, but whenever the acquisition, this is being done under army.
No, madam.
Border road organization.
Border roads. So
But
border
DO is
roads,
not
who
involved.
does it? Who makes the payment for the border roads?
My lord, only this, I'm submitting fairly, my lord. This in contempt petition, my lord. There is, my lord, there is an affidavit filed in the detention in my lord.
Oh, let that person be present.
My lord,
This affidavit can't go like this. A contempt matter of such affidavit after the affidavit.
Yes.
R.K. Raha, who is he?
RK Sahi filed, he transferred, my lord, he filed affidavit for.
So ask him to be present, Chief Engineer Project.
My lord,
Yes.
he filed for compliance, compliance, my lord.
What compliance?
Send it, my friend, to affidavit for compliance, and send to the Ministry of DGBR.
Ah.
The all proposal, my lord. He's affidavit, he's responsible, my lord. He's now transferred, my lord. Subsequently, this another also two they transferred, my lord. Then now this new one is there, my lord. He's obviously civilian, my lord, here, my lord, in Dimapur, my lord.
Very well, very nearby. We'll have it on Thursday. He can accompany Mr. Imti while he's coming from Dimapur. This can't happen like this. 29th. Less than on 29th. Then I'll consider the other one. Asking you, allowing your other petition.
29, I'll take instruction. With the personal appearance is equal.
Absolutely. Then take tomorrow instructions. We'll have it tomorrow. Get your instruction, then we'll have the personal appearance. The weather is very nice out here in Kohima. Stay one night.
Kindly, when 29, when I take for positive instruction.
No positive instruction. Positive instruction is tomorrow or 3:30.
3:30.
3:30. Positive instruction.
Payment, so far payment.
Payment. Today at 3:30, positive instructions. Then on 29, personal appearance.
Payment so far, my lord, the total payment of my.
Obviously, payment has to be total. Does the Supreme Court or the High Court say anything less than that?
I take it, sir.
Amount has to be paid.
For admission, item numbers 10 and 11.
Yes, what is this?
May I please, Lordship? Lordship, kindly grant me 2 weeks time to file my affidavit in reply to the affidavit in opposition filed by the state.
What is your case?
Lordship, here the petitioners who has undergone 3 basic combat training is claiming for the post under the Department of Combat in Civil Defense.
At the request of the learned counsel for the petitioner, matters in adjourned to be listed again on 1st of April 2024. The petitioner in the meantime would be at liberty to file a reply to the affidavit in opposition filed by the state respondent.
For admission, item number 12.
Please, your lordship. Lordship, I have received the affidavit filed by the respondent. So kindly allow me 3 weeks time to file reply.
First, huh?
For admission, item number 13 with 19.
Yes, Mr. Jamil, your matter. Yes, what did you do by filing this? You filed an appeal. This is a revision. Why have you filed a revision?
Appeal is not possible under the act.
Yeah. What are you challenging?
Your lordship, I am challenging the
petition. Is it the new petition? Civil revision. Yes, what is the ground of your challenge?
My ground is that the
Why are you challenging? The order seems to be right. No, what is wrong with the order?
Lordship, I am concerned about the mental and physical welfare of all my clients.
So
now, and since it is an interim, that it is not mandatory, it is even the provision for mandatory.
Now, has the matter been finally adjudicated by the authorities?
No, but since even the child was examined on that day, but the child's preferences were not even mentioned in the order.
Which order? Regarding?
Regarding the judge examined the.
Oh, that thing, the idea which I gave you, which is resonated to the filing of the instant petition. Yes, where is the order? The impugn order. Yes. Custody shall be divided in a year. The heir shall have the right of visitation of the child with proper information. we do one thing, Mr. Jamil. We don't interfere with this order. However, we direct the authority, the judge out there to decide on the visitation rights in a much, give more clearer directions. I think that is the better. Let him do it within a particular period of time, within 15 or 20 days from the date of certified copy, giving both the sides a reasonable opportunity. Let the judge decide on the question as what should be the visitation, means how the visitation, because what happens, 1, 2, and 3 already has become useless. 1, 2, and 3 has become useless. The custody of the heirs shall be divided between the petitioner and the respondent during the school vacation, 50-50, it's okay. But the respondent shall have the right of visitation with the prior information. I think this 5 and 6 needs more elaboration.
If your lordship may.
Or you want me to elaborate?
Yes, your lordship, because.
Why? Why should I elaborate? You see, why I'm saying is, this is the reason.
Yes.
These are matters which are adjudicated in camera.
Yes.
They would be better off, instead of hearing you or Mr. Jamir out there
Yes.
and deciding as to the child which is 1.5 years old.
No,
It's about 4 years old.
4 years old.
4 years old.
They go to school.
And the child. Yes, day before yesterday, I was seeing a documentary out there in Japan. They don't allow children to study till 6 years because of the fact there's no exam till 8 years. The reason is they don't put much emphasis. Here, both of you are putting a lot of emphasis on the child's education, who is just 4 years old. Let us not go into those. I think the better off is for that court to decide, taking into account the respective convenience of both the parties.
Your lordship, in that case, examination of the child also.
Examination of child, that, see, it's
The
a
child-
4-year-old,
the
the child may have a fear in appearing before a stranger.
No, she was produced before the court and examined by the court on that day, on 19.
So very well,
What happened? The court deliberately has not reflected what went on inside the child, in the presence of the mother and the father, your lordship.
So,
And now, if at all, the child is allowed to stay with the mother, the child is not inclined to stay with the mother, your lordship, for reasons known to the child. When the father left the home in September, the child clung to him desperately, so he had to take her. And even when the mother came to take her away,
see, just 2 days before I came out here, there was a talk by Justice V. Ramasubramaniam. He was a judge of the Supreme Court. So he was taking up a custody matter. And the original side in Chennai, Madras High Court, you have the original side. So he was taking up. When he was taking up the matter, there were son and daughter. The son was not inclined to go with the mother. And the daughter also openly says that I don't want to go with the mother. Then after some time, this judge told this lady, look here, both of your child doesn't want to come with you. Why you bent upon this, asking them that they should come with you? They don't like. And this child were 11 years and 9 years. Then the mother said, Judge, you do one thing, ask each of them separately, the son and daughter separately. So he said, okay. So he again called. The son said, no, I don't want to go with my mother. The daughter said, I love my mother. I want to go with my mother. But the fact is, if I go with my mother now or Delhi, I lose the love of my father as always or the love of my brother, which I can't. So under such circumstances, you do one thing. You tell me that you have to go with the mother. pass an order, and I'll cry in the court. But then also I'll cry. But you passed the order. So accordingly, the judge who was became a Supreme Court judge, so he passed an order. And this child, the daughter, cried out there on the floor of the court, saying, I don't want to go. But at the end of the day, she was the most happy. So the question as to whether she would, a 4-year, I'm saying about a 9-year, what will the 4-year-old daughter or son, whether he has an affection to the mother or not, these are questions I think better left with them. You see, at the end of the day, the question is the welfare of the child.
Yes.
If the child has a better place to stay out there in Kohima, where she gets a better school out here, or in Dimapur, it is the interest of both the parents to look into that.
Yeah.
So I think better off that later, I would say both of you, whatever may be, would like to further avail your opportunity out there and on the visitation rights of the child in Priya. Better?
And at least particularly about the child's preference. If the court wants to examine her in the absence of the parents, it's all right. But I am, to be honest, Your Lordship, I am very much concerned about her legal condition, Your Lordship. So, had she wanted to stay with the mother, it would have been a different issue. But because she is so close to the father had to bring her home to his parents' home. And even when the mother came to pick her up, she ran away. She was desperate. And this is the position, Your Lordship. So at least this aspect of the matter, a direction may be granted to the learned family court to closely examine the child, even on her own. The child is intelligent enough, Your Lordship. I assure you.
Yes, madam.
Lordship, my only anxiety is
Don't worry, I will protect both of you.
there is another child who is 6 months
Yes.
old,
Yes.
and they are living separately at present because the elder one is with the father. For the time being, by defying the order passed by the family court, the custody is with the father. My only anxiety is the academic session is going to be
Mr.
started.
Jamil, kindly don't go into this
And
academic.
then the
session.
school wants to have an interview with the child, and that will be within a week.
All these things, I think, better off before the district judge.
Lordship will do that.
Your Lordship.
I am not deciding
But
anything.
a
out
short-
there. I am saying that
Your Lordship,
taking into
yes.
account that, yeah, I think it will be better off and further opportunities given to both the parties to
Yes.
avail their remedies out there. And this court is not touching, however, it is the opinion of this court that the order requires some modification, which the court will do after hearing both the parties.
Your Lordship.
I think better.
Within a short time, Lordship. because
15?
the
15 days?
Your Lordship.
15 days appears to be little longer,
Oh, too long, 15, I think 15 days.
within 10 days, Lordship.
You see, it's very difficult.
I need not argue much on an issue like this, Lordship.
The proceedings before this court. And because, madam, you just heard who is for the petitioner in both?
I
You
am
are.
for the petition.
Mr. So-and-so appears on behalf of the petitioner in WPC number 8/2024, as well as Civil Revision 3/2024. And Mr. C.T. Jamil appears on behalf of the respondent in both the proceedings. Both the proceedings arises in view of an order passed this one, nah? Order passed by order dated 19/12/2023, passed by the learned court of the Principal Judge Family Court, Dimapur, in IA case number 70/2023 under sections 12 of the Guardians and Wards Act 1890. Full stop. The said proceedings emanates from the custody case number 12/2023. The record reveals from this court had duly perused the said order and the various directions which have been passed. There's a paragraph.
137.
No,
Paragraph, page 140, Your Lordship,
140.
page 140.
Direction is at
And
page
the various
140.
directions passed. Full stop. This court, after hearing both the counsels appearing on behalf of the parties, is not inclined to exercise the jurisdiction conferred upon this court in respect to the order dated 19/12/2023. However, it is the opinion of this court that the various terms and conditions as mentioned in the order dated 19/12/2023 may require certain modifications. It is the opinion of this court that the learned principal judge Dimapur would be in the best position to decide the modification of the terms and conditions, more so taking into account that certain clarity would be required as regards the visitation rights. It is also the opinion of this court that the respondents, that the learned principal judge would also be in a position to talk to both the father and the mother, and also have a word with the child.
Yes.
In deciding as to further, as regards the further, in deciding what further terms and conditions are required in the interim. Under such circumstances, this court therefore requests the learned court below, the learned principal judge, Family Court Dimapur, to hear both the parties and as well as hear both parties and decide as to whether further modifications are required to the terms and conditions in the order dated 19/12/2023, and more so in view of the visitation rights, which requires, in the opinion of this court, some more clarity. This court further requests the learned principal judge, Family Court, to do the same within as early as possible and preferably within a period of 15 days from the date of the instance certified copy No, from the date of when? Uh, From the date of appearance of both the parties before the learned principal judge family court. Before the state court. Appearance. Full stop. It has been submitted by both the counsels who have appeared before this court that the parties would appear before the learned principal judge family court on when? 1st of March? First? On 1st of March?
Your Lordship, it is 26 today's.
You are going to appear there only.
Yes.
So thereafter 15
Lordship.
days on 1st of March.
1st of March. And specifically,
Lordship,
Your Lordship, for the.
I have filed an
Both the
IA.
petitions therefore stands closed. Or with the both the proceedings stands closed in view of the above order, first of the interlocutory application. Right, separately, in view of the orders passed in both the proceedings, the interlocutory application stands closed.
Lordship, I have filed an IA for modification of the order passed by this honorable court on 19/12/2023.
What is that order?
IA is for vacation of the interim.
Instead of complying with the direction of the family court, they have approached this honorable court and obtained an interim order, staying the order of the principal
In
judge.
the main petition, you just write it.
And instead of complying with the order,
In the main petition after that. The interim order which has been passed in WPC number so and so. Shall be subject to further proceedings, further directions as may be passed by the learned principal judge pursuant to the appearance of all the parties.
What?
Which one will be taken up? 20.
Yeah. For admission, item number 20.
Recently, he might take charge, recently, but he is not aware of all this case, my lord. So, my lord, he requests, my lord, pray for some time, my lord, at least, my lord, 15 days or 20 days, my lord.
For what?
My lord, this is not before him, my lord. He is recently he took charge.
These are the contempt proceedings.
He was not.
Who is appearing for the contempt?
Contempt in one I am, but I already prayed my Bishop Security and Amora, they already there. They are in dispose of, they request me,
No, we will ask that, we'll do one thing, the personal, the facility which we provide of appearing through this here, I will remove it. Nothing doing.
In response to one repair, one pipe also repair.
You vacate the land. Vacate the land.
Yes, my lord, we have a proposal, my lord, the vacating land also.
When?
My lord is, my lord, may fix the time, my lord. Because this low land, my lord, is earlier also we trying to request, my lord. My lord, may direct also we vacate the land.
You will vacate the land?
Yes, my lord.
You give an undertaking?
Yes, my lord.
Tomorrow, give it on writing by way of an affidavit. Within what time you are vacating?
But tomorrow, my lord, this he is he is in Manipur, my lord. This today he went, my lord, the president.
Whoever it is, I'll an affidavit by day after tomorrow. I'll take it.
May pray on 8, my lord.
No, nothing doing. Vacate the land. Give an undertaking. You are vacating the land within such and such date.
Yes, ma'am.
Yeah. Then in that case, we will have it in this manner that the expenses of requisition expenses you have to pay. You have to pay the requisition expenses for using it from 2012 onwards.
That my lord.
You have to pay that. As per the rate,
Because
which is
our prayer also maybe earlier when at the my lord, there is my lord, only one part, my lord, we are using, my lord, the other part not, my lord.
I'm not concerned with using this way or that way when you are vacating the land.
Yes, ma'am.
Yes. Because the land having been acquired under the provisions of the 65 Act, the land has already, the petitioner has already been divested of his rights of the land. So under such circumstances, you will have to transfer the land back to the petitioner. So when are you doing the sale deed? Because you see, the right to information and the right to fair compensation act is not applicable.
Yes, ma'am.
So under such circumstances, once a land has been acquired and given to you, the right upon the land vests upon you. So under such circumstances, you are to execute the sale deed in favor of the petitioner.
My lord,
How?
here, what happened, my lord, this land was, my lord, our request to lease the land, my lord.
Your lease expired in 2012.
2012, up to it was 2013, my lord, as per this, thereafter, my lord, probably, I don't know, but maybe some rent was given, my lord. And
I'm not concerned about the rent.
Yes,
The rent does not arise thereafter.
yes, ma'am.
So under such circumstances, you are to transfer the land to the petitioner.
Yes, ma'am.
When are you transferring it? By way of a deed of sale? File it by way of an affidavit, because now the land vests upon you. I'll record it that you are saying that you are going to give the land back to the petitioner. So under such circumstances, when are you going to execute the deed of sale now to you?
In this, so I finally discussed.
What final instruction? That is the instruction we am asking. First, you are supposed to pay. There is an order passed by this court.
Yes,
You say that you don't want the land. Very well, don't want the land, you have to pay him, return him the land. Execute the deed of sale in the favor of the petitioner. When are you going to execute the deed of sale in favor of the petitioner? Because now the land has, the right upon the land has vested upon you. You can't do this.
Because of my award is there, we have not paid the compensation land.
You are going under, let us assume that you can go under section 12.
Yes, madam.
What will section 12 enable you?
Our compensation.
On reducing the compensation?
Yes, madam.
Nothing more than that?
Yes, madam.
So under such circumstances, you want to get your compensation reduced, meaning thereby you want the land. Now you are submitting that you don't want the land, because your submission is, we are enjoying a lease out there. So under such circumstances, let this land be, we will continue with the lease, not acquire the land. The petitioner does not want the land to be leased out. And if you see that agreement which was entered into in the year 1984, it categorically says on mutually agreed terms, it will be increased.
That is there.
They don't agree. So that is why the acquisition was done. Now, if you don't want the land, no problem. You have to return the land back. But there is no provision out there in the earlier act, like in the new act, whereby the land vests back if you don't use it for 5 years. So under such circumstances, the question of de-requisition does not happen. So if you don't de-requisition or de-acquisition does not happen, the concept of de-acquisition is foreign. So you cannot do that. The only way is you are to transfer the land, the rights of the land to the petitioner, free of cost. Not only that, you are to pay whatever the use the petitioner was entitled for all these years. Give an undertaking. Wednesday?
May submit, madam.
Wednesday?
Yes, madam. May submit. My lord, if lordship, this my so what is this oral my lord, this instruction, my lord, so my written instruction is required because I.
Wednesday. You are a central government council, get your instructions on Wednesday, or ask these persons to be personally present.
On witness the I'll take instruction on witness the mathematics, madam.
Why?
When?
Then the person has to come on Thursday.
Thursday first.
If you don't give instructions, written instructions on Wednesday, list the matters on Wednesday, on which state before which state the learned counsel appearing on behalf of the respondents and the petitioner in WBC number so and so shall file an affidavit as to what the petitioners wishes to do with the land. Let's see. Wednesday.
So what return of that also not reflected.
I'm saying on affidavit.
Only my lord, this day, my lord, because this week, my lord.
Okay, tomorrow.
Excellent.
Mr. Mehdi, you know, in Gauhati, all instructions are at 2 o'clock.
I know, my lord.
Then 10:30, 2 o'clock, 11:30, 1 o'clock also I fix it at 2. So here I'm fixing it at 5 minutes before to get up. You should have taken more time. You have been given 3:30.
28.
28.
20.
File your affidavit as to what, list the matter on so and so, on which state the petitioner in WPC, heard Mr. S.K. Mudi, the learned counsel appearing on behalf of the petitioner in the petitioner. The learned counsel for the petitioner submits that the petitioner never intended that the land be acquired. However, the district administration had acquired the land. Be that as it may, it is apparent from the records that the be that as it may, the instant writ petition has been filed by the petitioner seeking being aggrieved by the rejection of the application seeking reference under section 12 of the Nagaland Land Acquisition and Requisition Act 1965. The very filing of the application under section 12 of the said Act of 1965 and the rejection and being aggrieved by the rejection of the application, rejection of the said and being aggrieved by the rejection of the application prima facie shows that the petitioner herein is aggrieved by the amount of compensation awarded and nothing more. Considering the above, this court directs the petitioner to file an additional affidavit by 28/2/2024 on the basis as regards the submissions so made by Mr. S.K. Mehdi, the counsel appearing on behalf of the petitioner. List accordingly. But you need a copy. Take a copy, it is available in the internet.
Yes.
Isn't it, madam? Yes, good.
Yes.
Lordship, in fact, the land is wall, it's inside the complex.
One side not, madam. One side not, madam. The other side, there is a wall, madam.
And
It's okay,
the-
let them file a letter.
And the
Then
award
you-
also, my lord, it was a consent award that consented to the compensation.
No, now filing of that application clearly shows that. Anyways, let us see. Let them file an application. If they say that they don't want, I'll ask them to vacate the land and transfer the land back to you.
Along with compensation for.
Compensation during this period at the government rate which he had fixed at 900 rupees, because that agreement does not work. But the problem is your junior ought to have fixed that matter today with this matter, where madam has taken 3 weeks' time unnecessarily to delay. Yes. Yes.
Lordship, yes. My lord, the other day, if your lordship remembers, the matter relates to fixation of seniority. Now, lordship, your lordship,
So you will be, if I remember correctly, you will be now 470
lordship, yes,
and you have been given as 970.
yes. My lord, yes, lordship. If lordship, you can see page 67. Page 67, lordship.
Your date of appointment was?
My lord. Lordship.
12/3/93.
Yes, lordship, you can see page 83.
12/3/1993, you will be coming.
Lordship at page
to-
83.
No, yes, that I know. Yeah.
Then page 83, my lord, my name is
You will be
970.
four-
However, lordship, I should be below, I should be at 487 at page 67.
No, your appointment is 12/3/93.
Yes.
So your appointment will be somewhere in 489.
Lordship, if your lordship, you kindly see,
Kindly come to page 67.
yes, some.
486 is.
Yes.
1612,
Yes.
some mistake is there, but the others are 1393.
Yes.
1393.
So you should.
Yours
So I should
is
be at
12
489. 489.
489. And they have put it at 970.
Yes, 970. Then your lordship, may kindly confining to page 83, your lordship had raised a query about persons from 962 till 975.
So this has to be rearranged.
Lordship.
Without interference with the appointments which have happened in the meantime.
Lordship,
Only thing which this court can do is interfere with the seniority list,
Lordship,
giving it from, thereby direct the authorities to give you the,
my lord, unless and until my
to prepare
regularization
the
order-
seniority list in terms with this.
My lord, unless and until my seniority list is reviewed, the immune order is reviewed, Lordship.
Where's the impugn order?
One minute, Lordship. My lord, immune order is at page 37.
No, this I'll do it. I'm not on that.
Lordship.
That was not a problem. This
Lordship.
was never a problem. The consequences is this court will only ask them to treat you as an appointment on 16/1/2014.
Yes.
And your date of seniority has to be taken, date of regularization has to be taken as on 16/1/2014.
2004.
Four.
16/1.
And accordingly, the seniority list has to be.
Lordship, on this matter, can you allow me to refer to the 74 judgment, one paragraph, the relief granted by the Honorable Supreme Court, at page 37.
74?
Now, Lord, 1974
Yes, that day
for
you did it.
SEC 335. Book list was given the other day, so Lordship, 1974 for SEC 335. Then Lordship, yes. My lord, I can go straight to 348, page 348. Page, paragraph 37.
Yes.
The amendment shall therefore issue directing the appellants to restore, refix the place of Mr. Such and such in the seniority list in accordance with the directions of 1952 and taking into account other relevant consideration but ignoring the direction contained in board's communication dated November 2, 1957, January 13, 1916, 61 to the extent he have been held to be unconstitutional and invalid. If as a result of the refixation of the seniority as directed, such and such becomes entitled to be promoted or to be considered for promotion, he shall be so promoted or considered for promotion on an actual or notional basis with effect from the date on which such promotion or consideration for promotion as the case may falls due.
Well, you are challenging some order, 15/7?
My lord, page 37. I'm praying for review of page 37. Because lordship, instead of 16/1/2004, the effective date at A is with effect from 18 May 2010. Page 37, lordship. So my prayer and the writ petition was review of this order with all consequential benefits.
Okay.
And secondly, lordship, another point which my friend pointed out the other day. My lord, MACB was granted to me, my lord, at page 45. My lord, kindly turn to page 45, annexure N. My lord, on completion of 10 years, my lord, at page 46, my name appears as serial number 96. My lord, type copy, lordship will find it at page 48. My lord, here, the date of, if your lordship, page 9, serial number 96, Rakesh Rajan, graduate teacher, my lord, date of entry into service 12/3/1993, date of regularization 16/1/2004, and my lord, date of completion of 10 years was counted with effect from 16/1/2014. 2014, that is counting from 1993, with counting from 16/1/2004. Now, accordingly, I have been granted MSCP. Now, in the affidavit of the government, they are taking a stand that it was mystically given to me and they are going to recover.
That is not the subject matter of the petition.
Yes. But the apprehension, lordship, the apprehension.
Apprehension, after this consequential direction being passed.
Yes.
You will have.
My lord, I'm just waiting on to your lordship. Then, lordship.
Okay.
The
What else?
relief for the friend, the other day, lordship, were asking a query whether this relief can be, by sitting down, letting the principal, whether the same relief can be granted to the other fence sitters. To that, my lord, kindly allow me to submit a judgment. 2015, 1 SCC 347. Paragraph. Yes. 2015, 1 SCC 347. I think the book list was submitted this morning.
2016. 2016?
2015. 2015, 1 SCC 347, lordship.
1 SCC 347.
Yes. The relevant paragraph will be lordship, paragraph 22.
Yes.
My lord, the 363 paragraph, page 363 will be the relevant paragraph. Page 22, paragraph 22, lordship. May I read, lordship?
Paragraph 22.
Yes.
Yes.
The legal principle which emerge from the reading of the aforesaid judgment cited both by the appellants as well as the respondents can be summed up as under 22.1. The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending their benefit. Nothing doing so would amount to discrimination. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters, more emphatically as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently. 22.2. However, this principle is subject to well-recognized exceptions in the form of lashes and delay, as well as acquiescence. Those persons who did not challenge the wrongful actions in their cases in the acquiesced into the same and woke up after long delay only because of the reason that their counterparts who had approached the court earlier in time succeeded in their efforts. Then such employee cannot claim the benefit of the judgment rendered in the case of similarly situated persons to be extended to them. He would be treated as fence-sitters and lashes in delay and or the acquiescence would be a valid ground to dismiss their.
But this will be a judgment in person.
22.3 would make a.
Judgment in person, rem.
Yes, yes.
And if it is a judgment in rem, all the other people
yes,
will be in
and especially when the matter relates to policy matters like scheme of regularization. That is what Honorable Supreme Court in 22.3.
No, this will be a judgment in rem.
Yes,
so if it is in rem, those other persons.
Exactly, not in personam, because that is what 22.3 says, especially when the matter relates to policy matter with regard to regularization scheme.
Anything else? No.
No, not much of that.
Yes, madam. Anything?
Lordship, the appointment of the petitioner is not against sanction post. The Lordship, basing on the memorandum, he was regularized. The Lordship only in 2010 caused by a vacancy caused by promotion of a graduate teacher with effect, whose service was regularized with effect from 2004. Your Lordship, so Your Lordship, the impugn order, there is nothing wrong with the regularization of the petitioner.
No, it was against a transfer vacancy.
Your Lordship, no. That transfer was with post, Your Lordship.
No, understood, understood, it is a transfer vacation, but what is the requirement as per the
As per the
memorandum?
OM,
OM, let's see,
Yes,
page
Your Lordship.
24.
page 24, Your Lordship.
Yes.
Category 1, ad hoc contract. Appointments made against sanctioned posts. Employees having more than 10 years of service. An employee in this category may be considered for regularization provided there is a sanctioned post. The employee fulfills all the eligibility criteria for the post, including the requisite educational qualification, and the performance of the employee has to be satisfactory in the service. Your Lordship, here the petitioner has failed the first condition, that is the sanctioned post. His appointment is not
But
against
does
sanctioned
this
post.
office memorandum say
Lordship.
that that person's contract appointment was against the sanctioned post?
Yes, Your Lordship.
Does it mention in this office memorandum
Yes, Your Lordship.
that the appointment contract or ad hoc appointment was against the sanctioned post? Or does it mention that any person who is a contract employee or ad hoc employee can be regularized if there is a sanctioned post?
Only if there is a sanctioned post. Your
So
Lordship.
meaning thereby you had the sanctioned post. Any
Your
post.
Lordship.
See, if you see, just for example, you see section 53 of the paragraph 53 of the Uma Devi judgment. Uma Devi judgment.
Lordship.
The Supreme Court says that those people who were working for last 10 years against a sanctioned post
Lordship.
needs to be regularized,
Lordship.
can be regularized. But admittedly, the petitioner's appointment was not against the sanctioned post.
Yes.
There's no quarrel with that. It was against a transfer vacancy. Transfer vacancy, a post which is there, it keeps on moving with that person concerned. Means a person, not the person, if a person is transferred from A to B, then it is not a vacancy
Lordship.
out there. The vacancy has to be filled up. But are you saying that when the person is being transferred from A to B, that post is no longer there?
Lordship. Lordship.
Was the post there or not?
Lordship.
Post was there.
With post, Your Lordship, here.
Just for example, a person is working in a school in Mon. He is being transferred. That person A is transferred to Mokokchung.
Lordship.
Okay, he gets transferred out there. He moves to another post.
Lordship.
Now this post, which is there, does it cease to exist? No. Now a person can very well be appointed against a sanction post. If you appoint anybody, otherwise what will happen if a person is just being transferred out there, there will be many posts which are not sanctioned. And if there is no sanction out there, if a person is being appointed, there will be more persons appointed and sanction would be less. But in this case, admittedly, he was not appointed against the sanction post. His appointment was against the transfer vacancy. But is it the requirement of the office memorandum that his appointment has to be against a sanction vacancy? Or is it say that does it require a sanction post? You only say that there has to be a sanction post.
Yes, Lordship.
So didn't you have a sanction post in respect of others who were younger, junior to him? When you are considering those people who are having 5 to 10 years, you see, there are two groups, group 1 and group 2.
Yes, yes.
The group 2 are those people who are to pass an exam, having 5 to 10 years.
Yes, Lordship.
The petitioner herein admittedly had 10 years.
Yes.
Now, these 5 to 10 years who were being considered at that point of time, they were also, may have been appointed, whatever, maybe it's not known. They have given an exam, you have given them the appointment. Very well. Once you give him an appointment out there, these people, you will be appointing against a sanction post. When you are regularizing somebody, you will be appointing against a sanction post.  Now, once you regularize against the sanction post, There were other people who were having 10 years. They were to be therefore required to be taken into account.
The Lordship, yes.
So under such circumstances, these 10% or these persons who were that having 10 years and more normally gets a first preference.
Lordship, Lordship.
Because the first, here 10 years and above, they don't require to pass an exam. Only because of these 10 years, they are enjoying it.
Yes, yes.
And this office memorandum does not say that those persons who have been appointed against the sanction post on contract or ad hoc, they will be regularized. No, it doesn't say so. It says those persons, these people can be regularized provided, number one, there is a sanction post.
Yes.
Number two, employees fulfills all the eligibility, which he does. And number three, the performance has been satisfactory. The 2 and 3 is not in question. The first is the sanction.
Yes.
So under such circumstances, you could not have deprived him unless you would have said,
At the time when the OM came into force, Your Lordship, the petitioner is on thought, Your Lordship. So when there is no sanction post, how can we regularize the petitioner? Only he was regularized only in 2010 due to the vacancy caused by a GT who was.
but therefore the language of the OM should have said that those people who were in contract or year was against a sanction post. It doesn't say so. It only says that you are going to appoint provided there is a sanction post. Meaning thereby any person who have completed 10 years can be regularized if there is a sanction post. Makes it very simple.
Your Lordship, another ground we are taking is delay in benches, Your Lordship. In a period of 12 years, Your Lordship, this is service related and final seniority is already out. Now, if the petition is allowed, Your Lordship, it is going to affect the right of the third party, Your Lordship.
Therefore, the court can pass an order
Lordship.
that we be only given a seniority. The seniority list will be modified, but it would not affect the promotion or appointments of any other persons below him. What do you say?
Your Lordship,
Because you appointed him in 2010.
2010, Your Lordship.
That is the impugn order.
Without any
And he
objection.
approached in 2023.
Till 2023, he had no objection regarding the regularization order, Your Lordship. So there is a delay, Your Lordship, 12 years.
30.
Service matter, Your Lordship.
On that point, can you allow me to make a submission after him? I have, Lordship, may I, on this point? My Lord, I submitted my first representation. Because delay, my Lord, it was not properly addressed in my submission the other day. So, my Lord, my first submission, my first representation, Lordship may kindly see, I submitted, which is in page 13 of my reply affidavit. I submitted my representation on 15/9/2010. In my reply affidavit, I have annexed page 13 and 14.
Yes.
My first, my Lord, Annex T, page 13, it was received by the authority on 13/9/2010. That is, this is my first representation. Then Lordship may kindly come to my writ petition.
Yes.
The second representation I submitted, my Lord, thereafter at page 86.
26.
86.
Yes.
Then, my Lord, my third representation at page 88. I submitted 3 representations. Thereafter, Lordship may kindly come to page 90.
Yes.
May I read, my Lord, this letter? Subject to the Commissioner Secretary by the Principal Director, correction of effective date of seniority in respect of Mrs. Such and Such, and the subject cited above. I am forward herewith an application received from such and such. It is to be noted that was appointed as graduate teacher and ad hoc basis on 12 March 1990. Later, he was regularized on 5th July 2010 with the condition that effective date for regularization will be with effect from the date of cabinet approval, that is 18 May 2010. The teacher has stated that he has submitted all required documents to the department as well government such and such for regularization. However, his regularization was delayed May 2010 instead of 26 October 2006, when he already completed 10 years of service as on 16 June 2010. Therefore, this matter is still forwarded to the government for kind information and necessary action, please.
Now that I have read.
Thereafter, Lordship, I am coming to this. Thereafter, my Lord, I have made a categorical statement, and I'm making it over again, that the authority is the government, state government is sitting over it till date. Against again, we record the letter dated 20th April 2023, as forwarded by the principal director. Now, my Lord, to this, my Lord, I'm submitting a judgment to 2021, 1 SCC. 2021 was 1 SCC, paragraph 17, page 811.
Yes.
May I read paragraph 17? That the aforesaid discussion therefore leads us to the conclusion that writ petition was not barred by unexplained delay, as appellant had been pursuing the matter with the authorities, and it is the who sat over it triggering rejection of the appellant's letter such and such. The High Court therefore erred in dismissing the writ petition on the ground of delay. The illegality in the disproportionate nature of the order dated with no third-party rights affected never engaged the attention of this court on the judicious exercise of discretionary equitable jurisdiction. Consequently, the order of the High Court are set aside and the appeal is allowed. Now, with regard to third-party rights, Lordship, my Lord, with regard to third-party rights, my Lord, on this issue, on the specific query by your Lordship, I have submitted paragraph 15 of 1974 judgment, Lordship, which.
Yes.
My Lord, the question of third-party right will not arise here in view of paragraph 15 of 1974 for SCC 335, which Lordship, I can read again. Which was referred the other day. I may be kindly allowed to read again. Paragraph 15. Paragraph 15.
15.
Lordship. As regards the second objection, it is to be noted that the decisions of the Railway Board impugned the writ petition contain administrative rules of general application, regulating observation in the permanent department, fixation of seniority, payment, etc. of the employees of the erstwhile train shop departments. The respondent petitioners are impeaching the validity of two policy decisions on the ground of here being violative of Article 14 and 16 of the Constitution. The proceedings are analogous to those in which constitutionality of a statutory rule regulating seniority of a government servant is assailed. In such proceedings, the necessary parties to be implicated are those against whom relief is sought, in whose absence no effective decision can be rendered by the court. In the present case, the relief claim only against the railway which has been implemented through its representative. No list or order fixing seniority of the petitioner, particular individual pursuit of the impugned decision is being challenged. The employees who are likely to be affected as a result of the readjustment of the petitioner's seniority in accordance with the principle laid down in such and such were at the most proper parties and non-necessary parties, and their non-joinder would not be fatal to the writ petition. Then the relief is at page 37. So in view of this, paragraph 15, Lordship, the question of third-party right will not arise here. And with due respect.
No, understood, Mr. Takamasa, but the thing is 2010, 15/9/2010, you have submitted your representation. And then you slept till 10/11/2020.
The point is this, the point is, I fully appreciate. My Lord, if not for the letter dated 20th April 2023, forwarding my case to the state government for consideration, I won't be here.
So I can very well only ask the government to consider, that's all.
My Lord.
What do you say, madam? You consider that application. document without deciding anything on this? See, if the petitioner's only case is that, why should I decide as to whether the petitioner is entitled to on the ground of?
No, my
access?
lord. My lord, I'm submitting on the issue of delay.
No, on the question of delay only, if your cause of action
No,
has
my lord.
arisen in view of the.
So, and
2022
secondly, lordship, and the secondly, the second issue is lordship. This honorable court, my lord, under Article 226, have discretionary power to condone the delay, if any, because of the nature in which I have my right has been
But you
deprived.
slept over your rights for 12 years. You slept over. And the 2 days before I got another judgment, the submission of a, yes, he has brought it, submission of a representation does not enlarge the period.
My lord, if the state government had not acted upon my representation.
So you repent, I think the state government needs to look into that.
My lord,
as to whether it is proper or not and then decide.
My lord,
Lordship, on delay, I may be allowed to please.
No. See, there is a document where the principal director or something, somebody has written a letter. And you see that letter at page 86.
Yes, that we have seen.
Page 90. This principal director. Without other things, this was written in 2023. We consider it. That is the only thing. Without question, why should this court be reopen certain things? Because it is your person who have done this, reopen everything. Isn't he? Are you not representing him?
We are.
Then, if you are representing him, why you are not considering his case?
Regarding that.
That is your stand. Page 90.
Page 9.
Yes.
What is your stand to this document? Because here the principal director has forwarded it.
Yes, Your Lordship, to the
This
government, yes.
has been forwarded with on the. It has only been forwarded, nothing more than that.
Lordship.
He does not say that he is entitled to.
Lordship.
He says the teacher has stated.
Yes, Lordship, to consider, yes.
What have you done to this?
The Lordship, regarding that, I'm searching whether we have filed any reply to, but inadvertently we could not reply to that para, the Lordship.
No, understood.
So I
This
have
has been forwarded now.
Lordship.
Once it is being forwarded now, which means the government is still considering. Isn't it? The government has not stated, have not given anything to that effect, because you see, earlier representation was submitted on 15/9/2010. Then he slept for 12 years.
Yes.
Then on 10/11/2022, he submits a representation,
Lordship.
which is at page 86. Now this is at page 90,
Yes.
where the principal director forwards it to the government. So even after that also the principal director considered that his case requires to be considered.
I don't know whether this has been considered or not, Your Lordship, this way. Yes.
What?
Oh, yes, yes, I understand.
Hmm?
For the disposal of this representation, the lordship has direction.
Because if I direct them to consider this, you may reject it.
Yes, yes, your lordship.
The moment you reject it, again another litigation. Then your plea of laches and nea is gone.
Lordship, that, your lordship, that's why your lordship, I may be allowed to place free judgment, your lordship, of that.
On what?
the land leaches. your lordship.
No, the problem arises because of this letter.
Lordship,
Why has he forwarded it for the government to consider?
lordship.
If this letter was not there, the question would have been, he should have said that the question does not arise now.
Lordship.
But he is forwarded it to the government. But look here, kindly consider, he has stated this, what do you have to say? Now, if I direct you, that look here, okay, you now consider this, you'll definitely reject. Once you reject, and this also another very important aspect, as I can get it. You are saying that the petitioner was not appointed against a sanctioned post.
Yes, yes.
Okay. Then how did in 2010
Lordship.
you could have done him in terms with that if he was not at all appointed against a sanctioned post?
2010,
Yes.
lordship, he was appointed against a vacancy caused by a graduate teacher who was promoted to a higher post, your lordship.
Show me that.
That's at the, lordship,
Addition affidavit.
no, your lordship, I
Lordship, may I
have
read
only
back?
one affidavit, your lordship. I have only one affidavit. Para 6, your lordship. Para 6, your lordship. Your lordship.
Yes.
That with regard to the statement made in paragraph 6, 11, 14, and 16 of the repetition, the state respondent submits that there is no state cabinet's decision that all regularization should be effective from 16/1/2004. The state respondents averse that it was only after ascertaining the vacancy position due to promotion of some regular graduate teachers with effect from 16/1/2004 that the department magnanimously accommodated the petitioner against a sanctioned vacancy, and his service was regularized thereafter via order number so-and-so dated 5/7/2010. The effective date of regularization was fixed from 18/5/2010 as per the state cabinet's decision and approval. The petitioner has accepted the said order dated 5/7/2010 without any complaint objection at that relevant point of time till 2023, and no complaint representation has been received by the department from the petitioner since the date of regularization till 2023. It was only after a lapse of 12 years that the petitioner submitted a representation dated 28/3/2023 to the department for correction of his effective date of seniority. In this regard, the directorate filed later dated
So there is a decision of 610.
Your lordship, yes.
6/10/2023, whereby you have said that the petitioner case cannot be considered.
Lordship.
Now this is where the letter of 610?
6 with effect from 16/1.
This one.
Which one, your lordship?
Page 14.
Yes, your lordship.
AHM man, assistant headmaster.
Yes.
You are assistant headmaster?
No, I've never been promoted. Well, this is a different matter. 5th March 2023 is relating to others.
Ah, it's the same date. Same date letter. See the number. EDNL.
Which page? Which letter? Lordship is-
145.
Lordship is referring to which letter?
Page 90 of your petition. See the number of the letter.
ETNLGTSL 2020-170.
145.
Referring to which letter? To which paragraph you are referring to this?
No. Page 90 is the letter.
Yes.
Kindly come to page 14 of the affidavit of the respondent numbers 1, 3, and 4.
But
It's the same letter.
My there is no pagination here. So annexure, which annexure, Lordship?
Page 13 or 14, it will be see.
If Lordship, you can give me the date, the order date,
You see, this one, page 13, the order date is 6/10/2023.
And my lord, this is the one.
That's the same number.
My lord, the same number, but Lordship, may kindly see the contents. Matters relating to seniority list of graduate teachers under elementary and secondary teacher. I am directed to refer dated such and such. And
This is the number of the
presentation submitted by Sri Melissa. It's not me.
And 5 others.
And 5 others. But my lord, and recently promoted, and 5 other recently promoted assistant headmaster. Not me.
But this is the letter. You kindly see.
My lord,
145
the file
is
number
this.
may be used similarly, but then I have not been promoted at all. So it is relating to some other person, maybe they are using the same file number. My lord, the letter dated 6 October 2010, 2023 relates to representation submitted by 6 assistant headmasters, which I'm not concerned. Then the next document, 5th March 2012, is the approval letter with regard to 40 graduate teachers, my juniors, who had faced the interview, which I was referring to. And annexure is a direction for submission of my service book.
Finally, come to paragraph 3, page 3 of your affidavit of 1, 3, and 4. The state respondents, have you got it?
Yes, Your Lordship.
Submits that as per the memorandum so-and-so, which is also annexed to the petition in a year, regularization of the service of ad hoc having completed more than a year was for those ad hoc employees made against sanctioned vacant posts.
Yes, Your Lordship.
That is not the language of the office memorandum, no? Is it the language? As he was not appointed against the sanctioned post. Where is the necessity that he has to be appointed as per that office memorandum? That is not there. Yes, what judgment you wanted to show on laches?
Union of India versus Muru Gisan and Tarsim Singh case, Your Lordship.
Which paragraphs?
Tarsim case, it's at paragraph 5, Your Lordship.
Hmm?
Paragraph 5.
Which one?
Union of India versus
Mugaresan.
Tarsim.
Where?
Paragraph 5, Your Lordship.
By the office when the government to introduce the procedure for states for appointment of certain post approval of so and so. Then delay. The principles governing delay and latches are overlapping and interconnected. However, they are distinct. One may say that. Which paragraph?
Your Lordship, first,
Which judgment you are referring
Union
to?
of India versus Tarsim Sikh case, paragraph 5, Your Lordship.
Tarsam Singh.
Yes,
Para?
Paragraph 5, Your Lordship. Just the
Summarize,
principle,
normally a
Your Lordship.
belated service related claim shall be rejected on the ground of delay and latches is sought by filing an on or limitation where the remedy any one of the exceptions to the same rule in cases relating to a continuing wrong. Related claim is based on a one day. It can be granted even if there is a long delay. Mr. Takamasa, you will be entitled to any additional relief consequential benefits amounts?
Lordship, I am relying upon paragraph 37 of the judgment because it says entitled to be promoted if as a result of refixation of seniority as directed, Mr. Such and such becomes entitled to be considered for promotion on an actual or notional basis with effect from the date on which such promotion or consideration for promotion as the case may be falls due. That is why, my lord, I was referring to paragraph 37 of the 74 judgment. So, my lord, I respectful submission.
Now, are you going to get any money with monetary benefit?
No. I'm not, my lord, because once a seniority, because the question of monetary benefit, my lord, I leave it to your lordship. But the consequence, no, even notional promotion or consequential benefit, even otherwise, lordship. All those persons who are presently promoted are my juniors who has promoted to assistant headmaster onwards are all on officiating basis. On officiating basis, subject to TPC. So, my lord, if without any monetary benefit, even notional date is given also, because.
So, if I am giving you, would you affect the rights of those persons? No.
No, my
Yes, it will affect.
And the issue
It
is.
will affect the rights of
The issue is whether the question of whether it will affect your rights, whether it will affect the rights of my juniors or not is governed by 74 judgment. That is why I'm referring to paragraph 74, paragraph 15 and 37 of the Honorable Supreme Court judgment. Because Honorable Supreme Court.
Because if I allow, I'm not going to allow you. I'll be allowing a bunch of 20.
My lord.
With the bunch of 20
my lord,
going up.
The question is this. The question is this here, 120 persons in this 74 case, 174 4 persons has superseded the person concerned. But the Honorable Supreme Court says, even whatever it is, but
No, this is on the question, there is no delay here, no?
my lord, there is delay also. There is delay also, but delay also was reached.
Ah, 11, paragraph 11. Has
Yes.
raised two premium. The first is that the petition has filed 8 to 11 years after the issue of the impugned decisions.
Yes.
And as such was liable to be dismissed.
Then Lordship may kindly read paragraph 20, 21, and 22, which I have referred. So the Honorable Supreme Court here brushed aside the question of delay of 8 to 11 years and give the benefit at 37.
Okay. Then, yes, madam, the next judgment.
Lordship, next judgment, Union of India and others versus N. Murugishan.
Paragraph.
Uh, Para 18, 18, 19, 20, 21, 20, 25, 26, Your Lordship.
This is appropriate, reprobate.
Yes,
We
yes,
are not
Lord.
on that. Are you on appropriate and reprobate? No. Is it your case? No. He's not
That may
saying
also-
something and he's not asking for something, no. Appropriate,
there may be-
reprobate won't be there, but your case is on delay in laches.
Yes, Your Lordship.
And then the other one, another judgment, the new judgment, some state of Orissa versus here. Tarsam Singh has been considered. Union of India Mugarashan, delay principles. Chairman has been considered. There's nothing. Only law has been laid down. The overall disciplinary should have been non-suited on the ground of delay.
They also and relying on the principle of delay in laches, Your Lordship.
Anything else? Nothing? Hearing concluded, judgment reserved.
Much obliged, Lordship.
Hey, just give me the citations. The citations. Mr. Takamasa, would you ask your junior to give the citations and just write in a piece of paper along with the paragraphs?
Lordship, yes.
Yes, Mr. Joshua. You okay?
23 to 41.
My lord, I have brought the advertisement notifications.
What did he say?
After the 2010 batch and 2013 batch, my lord, all the advertisements have been issued by the Nagaland Education Mission Society, not a post created by the state lordship, as my lord has understood the other day.
You see, your case is covered by the judgment of the Supreme Court in Dhyan Singh versus Union of India, a state of something. You see,
That's a 1998 judgment.
as I could read the yesterday I had the occasion of reading, these posts were all SSA. This was done under the SSA.
Lordship, a post created by the state. And
Maybe, but
yes,
you see, how is a post created? Yes.
my lord.
Tell me, how is a post created? Let this court also be enlightened.
As my lord has gone through the notifications the other day in the government's affidavit.
No.
Yes,
Let
lordship.
us understand the very basics jurisdiction as to how a post is created. You can't create a post on the basis of somebody else's fund. No. A post is created if you have the money.
My lord.
You have to have your own money to have it in your own cadre. A post is created with somebody else's money. Cannot be your post because you cannot tomorrow, you cannot keep that post unless you have the money. So therefore, you see, there are two sets. The first set categorically shows that the money would be paid by SSA, and when SSA does not pay the money,
The
then
state will
the
pay.
state would pay.
My lord.
Now, the second post, the second notification says that those posts are to be created by for SSA will be there, but it does not say anything else. Now, what happens? The government takes a decision in 2019 that 2,909, isn't it? Teachers, 2,909 teachers who were there in SSA, RMSA, as well as something else, will be brought within the fold of the state cadre, isn't it? And there, in that notification, they have put it that they will be put below the rank of the regular cadres. And this is what you are aggrieved with.
No, lordship, there was no other regular cadre. The state made no other appointments. As far as the 2010 batch, which is by the advertisement in 2009, and the 2013 batch by the advertisement of 2011 is concerned, lordship, the governor of Nagaland has sanctioned this post. It's accept that the state has no resource, and the post creation was necessary, lordship. So the post was created.
Why the
by
posts were created? The posts were created because of the requirement under the SSA.
It doesn't say in the advertisement, lordship.
No, it has to be. Why will the SSA pay? It's the government of India flagship scheme.
Yes, lordship. So that's why, apart from the 2010 and 2013 batch, my lord, all the other advertisements have been issued by the Nagaland Education Mission Society, lordship.
Understood. Here they
My
made a mistake. But then also, who is going to pay? The question is the main, how does a person enter into a service or how his qualifying service can be taken. If you take the CCS rules, the CCS pension rules or anything, you require three things. The first is, it has to be in a substantive appointment of the government. Second, he has to be paid from the coffers of the government.
That's a peculiar circumstance which my lord may kindly appreciate.
The peculiar circumstances has been answered by the Supreme Court in this judgment. I have the habit of sharing my iPad with you.
Is my lord mentioned in a 1998 judgment?
No, 2002 judgment. Have a read this judgment.
My
It's a
lord.
very short judgment. Let us read for the convenience. It's an order. Give it to you.
Lordship. Now, while I'm waiting for that, my lord, now by the judgment
And
dated,
this judgment has been approved by the Supreme Court again in 2020, 16 and 12 and 16.
for that matter, one more thing, my lord, if my lord may kindly appreciate this, by the judgment and order dated 1/9/2017, the 2015 seniority list was challenged, lordship. And the present petitioners also filed 3 writ petitions, lordship. The 170K of 2017, 170.
You first read.
Yes, lordship.
Then we'll
My
go
lord.
further.
Lordship.
Yes, it's a very short order.
May I read out loud, lordship?
Yes, for him.
Service law, pension qualifying service, past service, benefit, when not admissible service.
No, no,
rendered-
no.
Yes,
Kindly
lordship.
come to the order.
Lordship. These appeals and the writ petition raise a common question as to whether the services rendered as an adult education supervisor under a non-formal education scheme evolved by the state of Haryana can be counted for the purpose of granting pensionary benefits as well as for the purpose of fixation of his pay. When such an employee is recruited to a regular post under the state government, either with or without break of service, needless to mention that these appellants, having served for a number of years under the Rural Education Literacy Project State Adult Education Program, the scheme itself under which they had been discharging their duties stood abolished, and consequently the appellants ceased to be employees. They had approached this court in a writ petition which was registered as writ petition number 1040 of 1990 seeking a mandamus to the state government for the absorption in any regular cadre of the state government. In the same case, the council appearing for the state of Haryana fairly submitted that the government is prepared to absorb the applicants in the state service as and when vacancies in the cadre of social studies teachers and masters are available. And on the basis of the state statement by the council appearing for the state of Haryana, the writ petition was disposed of with a direction that the government should utilize the past experience of these persons by absorbing them suitably as and when vacancies would occur in the post. As already stated, pursuant to the state direction this court, the appellants were recruited to the post of teachers on different dates in the year 1993. And they were taken into as fresh recruits. Their salary having been fixed at the initial stage of the scale of pay for a post in creation. The appellants therefore approached the High Court seeking relief that their pay in the scale of pay should be fixed, taking the past experience into account, and that the past services rendered under the scheme should also be taken into account for the purpose of deciding their pension. The High Court, relying upon the circular issued by the government on 13/11/1995, came to the conclusion that no part of the services rendered by the appellants as supervisors in the adult education scheme can be considered either for the purpose of determining the initial amount of salary which they would get on their regular absorption, nor can the same be taken into account for deciding the pensionary benefits, ultimately which the appellants would receive on superannuation from the regular services. It is this judgment of the High Court which is the subject matter of challenge in these appeals. Mr. Pankaj Kalra, appearing for the appellants, strenuously contended that the judgment of this court, the appellants having been given the regular pay scale while continuing as adult education supervisors under the scheme on the basis that they were discharging full-time duties, there is no rationale to deny the relief sought for by the appellants in the writ petition. Mr. Kalra also contended that the High Court was totally in error by coming to the conclusion that appellants had rendered service as part-time supervisors, which is believed by the earlier decision of this court, which is belied by the earlier decision of this court. He further contended that since under the government rules and regulations, the temporary employees, the ad hoc employees and work chart employees are entitled to count their services for the purpose of getting the pensionary benefits, it would be fair to it would not be fair to discriminate against a particular group of employees, though undoubtedly they had served a period under a particular scheme. Having considered the two contentions made and having applied our mind to the rules and regulations that were shown to us, we are not in a position to accept either of the contentions raised by Mr. Kalra. The continuance/engagement of the appellants under the specific scheme cannot be held to be an employment under any establishment of the government. Such schemes are taken for certain contingencies when money for the same is provided either by the central government or at times by some foreign countries. But employment under such scheme not being a part of the formal cadre of the state government, it is difficult to hold that a period for which an employee rendered a service under such scheme can be counted either for the purpose of deciding their pensionary benefits or even for fixing of their salary in the scale of pay once they are regularly absorbed. The judgment of this court pursuant to which the appellants were absorbed as against regular posts of the government itself would indicate that the court had taken a compassionate view and not on any rights which flowed from the past services rendered by the appellants under the scheme in question, and that also under the concession of the council appearing of the state government, we have not been shown any rules or regulations of the state which even confer pensionary benefits for such services rendered by the appellants. In this view of the matter, it is difficult for us to find any infirmity with the impugned judgment of the High Court. We therefore see no merit in these appeals in the writ petition, which are accordingly dismissed, but in the circumstances, there will be no order as to cause. My lord, respectfully, my lord, the circumstance of these two cases are completely different. It is not that there is no vacancy. I mean, a new post has been created now for their absorption. This is the same post which is continuing, lordship. So that is respectfully, my lord, if I have understood correctly, it's on a total different pedestal, lordship.
Now, are you saying that these are paid? Why will the SSA pay? It's a Government of India flagship project.
No, my lord, that's why, my lord. Now, apart from these two batches, lordship, the 2010 and 2013 batch, all the other batches, lordship, which is not a state post creation, lordship, their services co-terminus with the RMSA scheme, lordship, flagship program, lordship. In this case, the peculiar circumstance, given the financial position of the state, which my lord is fully aware, my lord, I need not go into the details. Now, knowing fully that the state can take an opportunity, they have created a post, lordship, a post sanctioned by the governor of Nagaland, lordship, by the state, lordship, the state governor. And the advertisement also issued by the government of Nagaland, lordship. Now, their pay was earlier met by the flagship program, lordship, under the RMSA. Now, we are not aggrieved by this notification dated 2/9/2022, by which our mainstreaming is to be counted with effect from 21/4/2022. As far as the pay component to be met by the state, we are not aggrieved by that part, lordship, but we are aggrieved by the part that our streamlining into the state cadre is to be counted with effect from 21/4/2022. We have already approached this honorable court in filing 3 different writ petitions also earlier to protect our seniority, lordship. And our seniority is to be covered by the earlier judgment dated 1/9/2017. Our matters were disposed of by the order dated 1/11/2017, specifically stating that the judgment and order dated 1/9/2017 will cover our cases, lordship, because we also challenged the seniority of those who were appointed through irregular means, lordship, and their seniority was to be counted from the date of their appointment, not from the date of their regularization. So our seniority has already been protected by this honorable court, lordship, by the order of this honorable court.
Show me that. Because how can that be a seniority when you are not being brought within? Yes, your seniority amongst yourself would be a question different.
Now,
but how can
2000
there be a
yes.
seniority consideration in respect to when you are not at all brought within the formal cadre of the government?
That this order has not been challenged by the state respondents, lordship.
But when were you brought within the fold of the government?
2015 seniority list, if I may take your lordship to the 2015
But are you
seniority
challenging the 2002, 21st of April 2022, wherein the state have stated that you have been brought within the formal cadre of the government?
No,
If you
lordship.
are not, then it will be deemed that as of now, on 21st of April 2022, you have been brought within the formal cadre of the government.
And that is the part which we are aggrieved, lordship.
Are you challenging 21/4/2022?
No, lordship, we are challenging the notification dated 2/9/2022, which states that our seniority is to be counted with effect from 21/4/2022. And the state in their affidavit have stated that we have not challenged the cabinet memorandum. It is a secret document. Even in the annexure itself, it's written secret, Lordship. It was not made available to us, Lordship.
Yeah, the cabinet memorandum is not required to be challenged. There's not,
My lord.
it's not a
Yes, sir.
document, but the orders which have been passed by which you have been brought within the fold of the government, are you challenging that?
Yes, we are challenging that with a prayer for modification, Lordship. As far as the pay part to be met by the state respondents, we're not challenging that part. But the part which says that our seniority is to be counted with effect from 21/4/2022, that part we're challenging, Lordship.
Now, are you challenging that from 20, you were all along a part of the state cadre from then?
Yes, Lordship.
Is it your case that
Yes.
you are part of the state
Because
cadre?
2015 seniority list, also the 2010 batch were included in the 2015 seniority list, my lord.
Sir.
We were part of the 2015 seniority list, if I may take a lordship to the seniority list.
Yes, where is it? Which petition you are referring to?
My lord, I'm referring to the 311 lordship.
311.
311.
Yes, where?
Page 395, my lord.
395.
Not 395, my lord, the 2015 seniority list. This is starting from page, my lord.
397.
No, my lord, page 196, annexure 119, page 196.
196. Show me the impugn order, what you are asking for, let me see.
My lord.
Quash the order dated demand issuing final seniority list without including the petitioners. Directed to modify onto the RIA dated mainstreaming the petitioner into the state demand. May be issued that the mainstreaming be related only on in respect to salary to be borne by the state. You are asking that direct or modify, alter the notification dated mainstreaming into the education, state education with effect from. So you want that you should be brought within the fold from the date of your appointment?
Yes, lordship. Well. My lord, the challenge to the 2015 seniority list. The judgment that was pronounced before our order dated 1/11/2017 was pronounced. The first judgment which covers our case is at annexure 120, page 204, my lord.
All SSA appointments, annexure 1. See, the pay and allowances of the appointees shall be borne by the state mission authority.
My lord is referring to which page?
Page 69.
My lord.
And Madam Additional Advocate General, your specific case is that they have been brought within the fold of the state cadre only on 21/4/2022, not prior to that. So under such circumstances, their seniority cannot be taken from that time.
Yes, because your lordship, I've faced the judgment also, your own judgment as well as a Supreme Court judgment, it clearly says that when a person serves in under a scheme, his period during the scheme cannot be counted towards
For qualifying service.
Yes, so even in our case also, prior to 2022, April 22, they are under SSA and under SSA.
Yes, you had made a mistake because you see, yesterday I was looking into the scheme of SSA is very clear. In fact, the chief minister is the president of the scheme of the state health mission, what do you call education mission or whatever. it may be.
Mission Society, yes,
Mission Society, the president. And thereupon all these things happen out there with the government. But the allocation has to be made by the central government on the basis of a particular, the financial involvement is on the basis of approval being given by the
Yes.
government.
So, Your Lordship, all the approval has been given by the Ministry of Human Resource Development.
Yeah,
Now it's,
yes,
the
MRD.
MHRD. Yes, so on the basis of that project approval board only, we.
Project approval board,
Yes, yes,
PDA.
Yes.
PDA.
PAB.
No, PBA.
Project Approval Board.
PAB.
Yes, yes.
PAB.
So on the basis of that, we created the post, Your Lordship. Yes. So, Your Lordship, it's very clear that the petitioners are under the SSA and RMSS scheme. They knew that they are under the scheme for which they have been approaching the government, making representation after representation. And only after that, the cabinet that took a decision that
to bring it within the fold
yes,
of it.
for 2010 and 2013 page, they will be gathered into the state.
But the others you have not.
Others, no. Yes, Lordship.
So therefore, this decision was taken of 2,909 or something.
Yes, yes, yes.
Or 2,099 something.
Yes, yes. So, Your Lordship, here the petitioners are challenging this entitlement notification. If at all they are against the general gesture of the government, even if they are aggrieved with the generous gesture of the government, Your Lordship, the option is left to the petitioner either to remain in the SSA scheme or to remain under 60. Lordship.
I respectfully beg to disagree, my lord.
You have seen, you have read my judgment on that old pension, no pension.
Yes, Operation Black.
There was the government did a generous thing of regularizing them.
Yes.
And then now they are saying that we are to regularize me from
the
that.
day when they were in the scheme. Yes, Lordship.
Now, my lord,
The same thing
the
with here.
circumstance of this case may kindly be appreciated. In 2015, when the seniority list came out, the 2010 batch were included in the seniority list. I have an ex-lordship.
Yes, Lordship.
Now
I
we have
agree
also
with that.
challenged the seniority list because we were placed behind those who were not regularly selected, lordship.
But all thing goes.
Yes,
The
we
simple
make a
thing,
mistake
what
before.
is there is, as of now, they say, the government says that they have brought you within the fold of the government education cadre only on 21/4/2000.
That is the reason why we are approaching this own court, my lord.
But how can you that show that you have been earlier brought merely making a seniority list unless the creation of post has been to be there?
And one more thing, lordship, which I have already placed this submission before your lordship, but my lord has many cases to deal with. So I understand if I may be allowed to refresh your lordship's memory. Now, when after the 2013 batch, when the 2016 batch, that is those who were appointed, advertisement also issued by the Nagaland Education Mission Society, and they approached this Honorable Court. Division bench, lordship, my lord has already dealt with that issue. The state has made a categorical statement, lordship.
There the state has said that look here, these people have been on a different cadastral and these people are different. In that case, what was happening is those people who were appointed in the 2016 batch were initially given 31,350. And thereupon, there was a direction by the state saying that you are only going to get 25,000. Kindly accept or forget about this thing.
No, lordship. The categorical submission is that we are appointed against a state sanctioned post,
Understood.
lordship.
Therefore, they approached the court, wherein our brother Sema, as he was the additional advocate general at that point of time, has submitted that look here, the 2010 and 2013 batch is different. You can't bring them within these batch. So under such circumstances, these people are different and cannot be equated.
No, my lord.
Single
My
judge
lord.
has held it, yes, 2010 and 13 are different from there. And under such circumstances, these people are not entitled to.
No, my
And the
lord.
division bench went out there on the basis of Jagjit Singh held that they are entitled to the scale of pay. Though I was a co-author out there, but I have strict reservations on the judgment in
No, my
view
lord.
of
If-
that judgment, which I showed it to you on parity of pay, 2018-19 SSC, that judgment.
As
for
far as the
which
pay
your-
part is concerned, lordship.
For
we are-
which your VGR matter have
My
not
lord.
been able to take it
Lordship.
up.
As far as the pay aspect is concerned, lordship, we are not into that case. But can the state approbate and reprobate after making a categorical submission that we are appointed against a state sanctioned post?
How can they be state sanctioned post? The state may create they may not know properly, but you cannot create a sanctioned post unless you have the budgetary allocation. You don't have the money, you cannot create that.
No, my
Yes,
lord.
tomorrow you want to, the moment you do it, you are to bring it within them. You cannot create a sanctioned post. And if you have done it, they have done it wrongly. Just for example, tomorrow I ask the government out here, in this court we need another 4 peons. Would the government do it? No, the government, the chief minister may say, "Hey, very well, I'll give it to you." But the fact that it has to be on the basis of a concurrence from the finance department, then finance department has to look into it. There has to be a budgetary allocation being made from the state coffers. Unless it is not made. So therefore, one of the 3 conditions for getting a pension is it has to be made from the payment of the government. Why is it required? Because the payment, if it is made from other sources, cannot be drawn within the fold of the government.
Then in that case, my lord, my lord may kindly appreciate this aspect. The GPF, EPF lordship. Where our salaries, since we are appointed on sanctioned post, regardless of whether our salaries were met by the CSS scheme lordship under RMSA or not. We have been making all these deductions unlike the normal CSS sponsored, centrally sponsored scheme appointees lordship. So lordship, everything, all the nature of our service and the nature in which our service has been
You will
regarded lordship.
obviously, as of now, you will be getting all the CSS benefits which are there as per the, you don't get as per the, you will get it in view of Rule 2 of the CCS pension rules. You are a government servant now.
The same lordship, the same nature has been continuing lordship. And the same was not made applicable to those who were appointed after our 2013 batch lordship. So my lord, if my lord may like me to satisfy this honorable court or any coordinate bench lordship, then I may be allowed some time to bring all those records to place before your lordship, this honorable court, that our category as employees of the state lordship, that we have been treated as state employees, and of course, as my lord has already observed in the division bench judgment also lordship. Now, it amounts to adopting your own child lordship if the effective date is to be given with effect from 21/4/2022 lordship.
Then on that date, you will be there. You will be taken into account from the state cadre. Earlier, prior to that, now SSA cannot make the payment. Now SSA is not making. The SSA cannot now take the payment. The payment has to be now made by the government of Nagaland. The sad part is you may not get your salary in time, but now earlier the government of India was paying. I think it's 90-10, no?
Yes, 90-10.
90-10.
Lordship.
Hello, judgment reserved.
No, my lord, respectfully, my lord, I may be allowed to satisfy this honorable court
Okay,
by giving me another opportunity. my lord.
Tomorrow, the files are not coming. You make your submission at 12:30.
My lord.
12:30, you make your
Lordship.
submissions.
My lord.
Files are not necessary. Otherwise, I'll give you another 15 minutes. Okay.
What is it? Tomorrow, again, 12:30.
Tomorrow. Yeah. Pass over. 12:30. What? The names of the councillors? What, item number 20? Oh, let him write.
Hey, to show me put your judgment reserves and this is a shit for you, the mama.
Gepu san na lang po ha. Sida ho, court sida ho.
Yes. Oh. God.